My lord, item 27, may I check the record? Item 27, can I check the record?
My lord, we due consent from other side, my lord. I beg to mention item 16, my lord. 16. And this matter may be listed after 2 weeks. Fail hearing, my lord. Yes, respondent. Yes, my lord. In the trial court, my lord, that is fixed on 10, my lord. They will appear on the day. Thereafter, my lord. Yes.
Very consent of the other side. The Guardian Council for the respondent, Mr. T. Hussain, writ by adjournment. So the extension made by Mr. Hussain, let the matter be accordingly listed. After cross take of this after that. 1-3.
Deeply, my
It pleases your lordship.
1-3. Yes.
My lord, due consent of the appellants, my lord, I beg to mention item number 10. I pray for 1 week's time. I appear for the sole respondent.
So respondent.
Yes, we are appearing on period. I seek 1 week's time.
Consent of the other side. The Guardian Council appearing for the respondent. Wait for an adjournment. So you have already appeared for the sole respondent.
Yes. We are yet to file objection in the IA, my lord. That's why I seek this time. That is why it has come
That-
forward.
So in that case, it will be again in order call.
Yes. It will come.
After 2 weeks, will do.
I sought consent for 1 week. They allowed the lordship.
1 week, though we don't. You want to fix it? Fix it.
No, we don't want to pick.
Achha, okay, then after 1 week, as on a date will be. In that case, we are listing it after 1 week.
Yes, highly observed.
May I please, I beg to mention for listing on material on an epic manner.
You approach before court number 13.
May it please your lordship. With the consent of the other side, I beg to mention item number 4. My senior is
Item number 4.
Item number 4.
It's a transfer petition.
Yes,
I am for the petitioner, lordship.
You are for the petition.
I am for respondent number 6.
Yes, my lord.
It is otherwise transfer petition. Why there are many respondents? These are all are accused or what?
No, lordship. Actually, the petitioner have filed one that happens in the district court, lordship. Because of,
Okay.
because of some ailment, lordship, they are not in the position to travel from Lakhimpur to Tinsukia, lordship. Kindly fix it on 3rd week of February, lordship.
Considering this submission made by Learned Council for both states and also considering the request made by Learned Council for the respondent number 6. Let the matter be 13th. I don't know. You want to fix it here?
Lordship, that may be fixed on 3rd week of February, lordship.
27th of February.
27.
Yeah, please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 26, lordship. Lordship, kindly fix this matter on 17th February.
You are for whom? You are for appellant?
I'm for the petitioner, lordship.
I'm the respondent, your lordship.
Respondent. The request for the Learned Council for the with the consent of the other side for the respondent paid for an adjournment. No, petitioner paid for an adjournment. Will be listed after 2 weeks. We cannot fix a date. After 2
Lordship,
weeks,
it's an
as the
urgent
date.
matter. Kindly fix the date.
That date, if you want to fix a date, then it will come on in the month of March. March will do. Otherwise, we're listing it after 2 weeks because it may be accommodated in any court.
Okay,
This court may not be possible.
Then 5th of
After 2
March.
weeks.
10 of March fix. Lordship,
After 2 weeks.
after 2 weeks.
If you want to fix it, it will come on March.
Lordship, then kindly fix a
March.
March.
Okay, March or
Fix date on March.
17th of March.
Lordship, 10th of March.
No, 17th of March.
2
Okay.
weeks then is in here.
Yes.
Okay.
Yan 21 right.
May I please, your lordship. My lord, in regard to item 5, my lord, so far impugn order is concerned, it is in the file, but it has not been annexed. So your lordship give me just 1 week time to rectify that.
It is in the record and not
It is
annexed.
there in the file, but it has not been, in the index, it has not been given. So that rectification possibly you were.
Even if suppose it is not there, then we hope.
It is there in the file. I have just checked it. Certified copy is there.
And the order was of 5/5 or
No, 29/4/2025. 5/5 is a subsequent one.
so you want to make a rectification in your
In the
Index.
FAO, man.
no, FAO.
FAO also in the index.
Mr. Esther. Done it. Look at Mr. Esther. The counsel for the applicant. It is submitted by Mr. Inadvertently. The uh, copy of the order, impugn order, which has been which is furnished along with the FAO, is not mentioned in the index copy, and hence index, and accordingly it's submitted that there needs some correction in the index, both in FAO number 6 of 2026 as well as ISC with 246 of 2026. Prayer out. The appellant will take necessary steps in inserting the copy of the order which has already been annexed, which is already available in the case record. And the necessary amendment of the correction will be made in both FAO as well as the connected I. After necessary correction, the matter may be placed. After 2 weeks will do. You know, you want a
13th
date
to
fixed. Huh?
13th of this month. 1/3.
1 3.
Much obliged.
May it please, Lordship. Well, this is not a fit case for mediation, Lordship. Liability has been settled with the owner, and we have challenged that part mainly.
Part Mr. M. Talukdar, he done a counsel for the applicant, and also part MSP Board done a counsel appearing for the
Respondent number 3, Your Lordship.
Respondent number 3, Public Insurance Company. It is submitted by Mr. Talukdar that there are some law points which are involved in this case, and accordingly, it may not be a fit case to send it before mediation. Next, but considering the submission made by Learned Counsel, says, let the matter be. Otherwise, what is the stage? I see in order column.
His
it has to
lordship,
be-
order from lordship.
Let the matter
Oh.
be accordingly listed after 2 weeks in order column as on a date to be fixed by the registry.
Obliged.
Obliged.
This is a lordship.
Yes.
Lordship, though the case is on quantum lordship, but the amount of judgment is higher than what the regional office has power. So lordship, if it is sent in mediation, the authorized person won't be able to come from head office lordship. That's why the case may not be sent to mediation.
Yes,
No, will come from the head office over.
No,
No, lordship.
it will be fit for hearing only.
No, that will come later. No, why you are saying authorized person, why he cannot come?
Lordship, because they are from outside lordship. And moreover, already the claimant council has contacted them for a compromise settlement. But that letter, that authorization has not yet come. So even if it is sent to mediation lordship, then it won't be settled. It will be a futile
Whatever,
exercise.
LCR has not come, Lordship. And 50% has been deposited. so-
Otherwise, all the respondents have appeared here.
Yes,
No, we have struck off, I think, lordship.
5-6
5, 6.
and 1 to 4 have appeared, Lordship.
You are appearing for 1 to 4.
1 to 4. LCR has not come, Lordship.
RDMS, RD Mujumdar. For Mr. A.R. Agarwal, they done it appearing for the claimant respondents number 1 to 4. And the learned counsel for both the sides accordingly submitted that may not be fit case to send it for mediation. Considering the submission made by learned counsel for both sides, let the matter be listed in here.
Lordship, then the one IA is there, Lordship. Next IA is there. 50% they have deposited, so that is to be released.
Not going to pass anyhow. List the matter accordingly. Now, in that case, it will be in order column.
Yes, Lord.
Let the matter be listed accordingly in order column after 2 weeks as a date to be fixed by the registry. At the same time, the registry is also hereby asked to directed to call for the DCR list account.
Lordship, that IA, Lordship, IA 3569, Lordship.
Lordship, we will file our objection. We could not file in the meantime because
These are cases today is only for identified for mediation only.
yes, Lord.
We are not going to pass any.
I live that.
Lordship, one date may can be fixed on
2 weeks.
2
it said
weeks
so.
after 2.
May I please, Lordship? In this matter, my service is not yet completed, answer notice returned. May I pray for
Answer notice return.
return for a press step
Acha.
for respondent matter.
So respond. Hard
Ibora.
hard MSP Bora, they done it of the appellant. The case is identified for mediation, however, it is seen from the office that service is not yet completed on the respond number sole respondent, and it has returned with a posted remark incomplete address. In view of this, matter could not be sent for mediation. However, the appellant is hereby directed to collect the present and proper address of the sole respondents and to take steps. List the matter.
After 2 or 3 days, date may be fixed.
Date want.
Any date. I will be allowed to take press step.
Yes, you are going to.
Lord.
Obliged.
My lord will give this. My lord, already I have made submissions in this case, my lord, just to refresh. Well, that small piece of paper, my lord, I'll just sum up the basic details of this case, my lord. He was arrested on 13/11/2024. 1 year, 2 months, 24 days he's in custody. She. And charge sheet filed on 14/5/2025. Charges framed on 30/7/2025. Total number of witnesses 9. Witnesses examined so far none. And grounds is one is prolonged incarceration, and the second, the ground of arrest not communicated in a language that petitioner understands. And grounds of arrest not communicated to the family members, relatives of the petitioner. Co-accused, there were in fact 4 accused persons. One died in custody and the other 2 got bail, and she is the third one. So my lord, in fact, she is the only accused in this case who is behind the bar. And my lord, the records, my lord, on the last day I indicated that those 48 notices which were sent, it was sent to one police officer, that is in a WT message, and there were certain blank 48 notices from the records. Then your lordship called for the case diary. And my lord, the office note dated 5/2/26. Office note dated 5/2/26 says that they have received the case diary. I have perused that also, my lord, today morning. Even in that case diary also, the 48 notices were just WT message to the police officer of this concerned locality. No relative, my lord, no notices were sent to any of the relatives, and which is evident both from the court record as well as from my petition, which is again corroborated with the part of the case diary which has been received by this court. Now, my lord, these are certain judgments, my lord, which I am relying with. I have indicated the para numbers, my lord, which will show that violation of 48, that is relative, is violative of Article 22, and there is a clear indication, my lord, that in such cases, any amount of detention would be an illegal detention. My lord, I'll give that copies, my lord, of the judgment so that you have arranged it in this way. একেলগে দিলে গোটেইখিনি এইটো এটা পিছত এটা এইটো তলত ওপৰত দিব But I have arranged it in the manner I have written it in this, so that it is easier for the court, my lord. Otherwise, my lord will take the first judgment, Kasika Reddy. My lord may straight away come to para 18H. 2025, these are all recent judgments, my lord. 2025, para 18H. Internal page number, your lordship may para 18. What is the internal page number?
21.
Internal page number 21. Internal page number is in fact in SCC online. It is on the left-hand side top. 21, my lord, is there, my lord?
21.
Para 18, internal page 21, para 18, 1/8. Thus, the following principle of law could be said to have been laid down, rather very well explained. Para 18. My lord, I skip everything because what is relevant for this case is H. The grounds of arrest should not only be provided to the arrestee, but also to his family members and relatives, so that necessary arrangements are made to secure the release of the person arrested at the earliest possible opportunity, so as to make the mandate of Article 22(1) meaningful and effective, failing which such arrest may be rendered illegal. And thereafter, my lord, though many times, my lord, this court has gone through Vehan Kumar, but in Vehan Kumar, there is one interesting part, my lord. In Vehan Kumar, this is a 2-judge bench judgment, my lord. One is Justice Okha and Justice Kotakar Singh of our High Court. The observation of Justice Kotakar Singh on section 48, that is what I'll rely, my lord. My lord may kindly turn to paragraph 3. Now, paragraph 3 of Justice Kotakar Singh's judgment. Koteshwar Singh, sorry, my pronunciation, my mistake. Para 3. Internal page 19, that is the penultimate page. Last but one. Para 3. The purpose of inserting section 50A, which is in parameteria with 48 of the BNSS of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relative, or person nominated by the arrested person is to ensure that they could be able to take immediate and prompt action to secure the release of the arrest person as permissible under the law. The arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release, which would otherwise be available to the friends, relative, and such nominated person by way of engaging lawyer, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relative as mentioned above is not only merely a formality but to enable the detained person to know the reason for his arrest, but also to provide the necessary opportunity to him through the relative, friends, or nominated person to secure his release at the earliest possible opportunity for actualizing the fundamental right of liberty and life as guaranteed under 21 of Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to his friends, relative, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Now, my lord, the next, my lord, Mihir Ranjan Shah, that is also 2025, paragraph 47. My lord, here, my lord, I am relying on the sentence which is starting with simultaneously. That is important, my lord. That is 1, 2, 3, 4, 5, 6. 6 line from top. I'm just trying to segregate things which are not that much germane, my lord. Simultaneously, a duty has also been cast on the person making arrest to forthwith thereafter inform of such arrest with reasons and the place where the arrested person is being held to the such indicated person. The police officer making any arrest shall make an entry of the fact as to who has been informed of such an arrest in a book to be kept in the police station. So, my lord, even in Mihir Shah also that it has to be immediately informed, my lord. And division bench, yes. And my lord, a division bench judgment of this, our High Court, my lord, because this division bench judgment, if your lordship remembers, there was a, my lord, there was a divergence of opinion between two judges of the Supreme Court. Initially, they said that the ground of arrest should be communicated in writing by a two-judge bench. Again, another two-judge bench subsequently said that oral will suffice. So there was a confusion, my lord. So therefore, my lord, different high courts had different. So this matter, our High Court referred it to a division bench. The division bench said the earlier will prevail. That is, it has to be communicated in writing. That was in this particular, my lord, judgment, the division bench of our High Court has clarified it. And I rely on para number 13, 14, 16, and 17. That is burden to be informed to the relatives. I am on that, my lord. Para 13, if your lordship kindly, my lord. It should also be noted that the Supreme Court in Vihan Kumar held that para 21C, in para 21C, that when an arrested accused alleges non-compliance with the requirement of Article 22(1), the burden would always be on the investigating officer agency to prove compliance with the requirement of 21(1). The burden is always on the prosecution to comply. Then paragraph 14. In the present case, the appellant has not been able to prove that they have complied with the, here, my lord, appellant is the state. In this particular case, appellant is the state. In the present case, the appellant has not been able to prove that they have complied with the requirement of Article 22(1) insofar as the communication of the grounds of arrest of the accused respondent had been communicated to his family members. My lord, if I may just take a pause, my lord, what happened in this case, so interesting, my lord. In this case, there was a memorandum of arrest, which the prosecution says is signed by the relative. The accused disputed that. The court ruled in favor of the accused because that signature admittedly was of a person unknown and there was no date. So it raised a doubt in the mind of the court that in some places there are dates and some places there are no dates. So when there is a difference, I mean, when there are two views are possible, the views in favor of fundamental right will be taken. So in this case, in fact, my case is much better. The present case I'm arguing much better than this case. Here there was a signature. And in my case, there is only some W2 message to a police officer. Now, my lord, the next para is para 16. Para 17 is what I was mentioning, my lord. We have perused the records that have been bought by the appellant, though there is a signature in the photocopy of the arrest memo of the accused respondent, which the appellant say is the signature of the brother of the accused. We find that there is no date affixed to the said signature. On the other hand, all other signature in the arrest memo, which have been signed by the witnesses, the arrestee and the officer making the arrest, all have dates. There is nothing to prove that the grounds of arrest has been received by the brother of the accused on 25/20/25. That the burden is so high on them because at the end of the day, it's a question of violation of the constitutional mandate that little bit here and there, the benefit will go to the accused. Be that as it may, my lord, and the other paragraph, my lord, paragraph 17, okay. And my lord, on Acha. Now, this is one single coordinate bench judgment, recent 2025 November judgment. This is also our High Court judgment, para 9, my lord. Your lordship will just mark para 9. It is all the same. I'll not waste court's time by reading it. Say para 9. It again says the same thing. Section that if it is not communicated, then and it was not communicated, and therefore they were enlarged on bail. And my lord, the other ground which I have taken in this case is that the ground of arrest was not communicated in the language the accused understand. Before that, my lord, I'll have to take your lordship to the section 47 notice which I have annexed along with this. My lord, may kindly come to page number 31 of my bail petition. My lord is there. My lord will see the grounds of arrest. It is written in English, typed, my lord. And this lady, she has put a thumb impression. My lord has seen, my lord, on the left hand side, has thumb impression. So, my lord, my client say even except Assamese and some Gwalparian language, my lord, she does not understand, at least she doesn't understand English, my lord. Now, my lord, please read this with para 44 of the last judgment, Mihir Ranjan Shah. Mihir Ranjan Shah, para 44. My lord is there, my lord?
Yes.
This I'll read, my lord. On perusal of the above two judgment, it turns out that mere communication of the grounds of arrest in a language not understood by the person arrested does not fulfill the constitutional mandate under Article 22 of the Constitution of India. The failure to supply such grounds in a language understood by the arrestee renders the constitutional safeguard illusory and infringes the personal liberty of the person as guaranteed under Article 21 and 22 of the Constitution of India. The objective of the constitutional mandate is to place the person in a position to comprehend the basis of the allegations leveled against him, and it can only be realized when the grounds are furnished in a language understood by the person, thereby enabling him to exercise his right effectively. Now, my lord, if your lordship remembers, probably it will be there in the record on the last occasion, because recently, my lord, I have come across one case that was very striking, my lord, from Nagaland, my lord, where a man from Bihar was arrested. They has ensured that the grounds of arrest has been communicated in Hindi language. The grounds of arrest, the notice by which the grounds of arrest was, it was in Hindi, East Police Station, Nagaland. So that is how you respect the mandate of a constitution. Mere formality, my lord, everybody can do. That is what the Supreme Court was time and again trying to remind the investigating officer that something is provided in the constitution, respect it, do it the way you are at liberty to take whatever action. That's my case, my lord. 1 year, 2 months, 4 accused, Two are already released on bail. She's the only one.
Lordship, firstly, I want to state here, Lordship has to, in this case, has to strike a balance between the gravity of the offense, because in this case, 10,000 Yuba tablets are there, Lordship, and in methamphetamine, Lordship, only 50 gram is required for commercial quantity. Secondly, Lordship, and I also acknowledge his rights, fundamental rights also to be respected. But firstly, I want to go to the page 47, under section 47 BNS, Lordship, page 31. If I put one question, Lordship, since even if it is, if I presume that it is in Assamese also, she would not have been able to read that. I have reason for that, Lordship, because she is an illiterate. She is an illiterate, so she has put the thumb impression, Lordship. If she is a literate person, then she should have written in Assamese, Lordship, if she knows Assamese, Bengali, whatsoever. She herself does not know the language, Lordship, to how to read or write. So in this case, even if it is have been in the language of Assamese, she would not have been able to read. And for that, if she has been communicated to it or not, I have to go through the CD, Lordship, and I have to look into the CD in the entry. Not the CD will be suffice, because in the entry, it will be stated whether she has been communicated or not, Lordship. And if I have looked into the CD, and what is there in the CD? It's the statements of the witness, accused person, the charge sheet, and Lordship, this 470, 47, 48. So I cannot infer from that whether that has been communicated or not. But I can infer one thing. I can infer one thing from reading the order, Lordship. What is there in the order? Order dated, Lordship, 13/11/2024. It has been clearly stated that the magistrate, learned magistrate, Lordship, it has already been stated that her rights has been made aware of, including this grounds of arrest, Lordship, and she has stated that she will engage her own counsel. And in this case, Lordship, moreover, in 48, I will go to 48. In 48, my learned friend has already stated that she has to nominate one person, Lordship, because she is from another district, and she caught in another district, Lordship. She was caught in another district, and she was from another district. How her relative can be informed? Obviously, she has to be communicated with WT message, and WT message what the other police station has does. I again have to look into the entries, Lordship, whether they have communicated or not. Merely stating that there is a W2 message, so it has not been communicated, it cannot be inferred like this, Lordship. It is because of that I have, in the very first line, I have stated that the court, this court, honorable court, has to strike a balance between the society and the individual rights, Lordship. Yes, it is the individual rights are important, but at the same time, there are also some reasonable ground restrictions are also there. Even in the Article 19, 21, everywhere in 19. That is why I am stating that. I am stating that, Lordship, in the CD, I cannot infer whether the grounds has been communicated or not, because these things are there, Lordship. And in regard to 48, WT message has been given, and it is not clear from him also that whether he has been, police station has communicated in not, it or not. And she is an illiterate person. It is not in the cases. What he have cited, Lordship, I very well know that, Lordship. What are the obligations of a prosecution? I very well aware of that. But whether it covers that if an illiterate person is there, what will have to do? It is not there. In my limited knowledge, I can say that, Lordship. So this is a peculiar case. And in this case, even if it is written in her language, own language, she won't be understood. And in the, I have already stated that in the magistrate judgment, Lordship, it seems that I can infer, Lordship. Lordship can also infer that or not. I don't know, Lordship. Lordship can look into that. But I have understood that everything has been made aware of it. If she does not know aware of it, then she should have definitely objected to it. That I have given this 48 or 47 notice, but I am not aware of these things. Because it is in Assamese, I am know only Assamese, it is not written in Assamese. She has not done this. And in the petition also, my learned friend has already stated that he has come on another occasion also where he has not mentioned about the ground of arrest. Here also, Lordship, such an important right. Here also, my learned friend has not communicated to this court that her ground of arrest has not been communicated. In the lower court also, the learned trial court also, they have not communicated to it.
What communication? means?
Communication that her grounds of arrest has not been communicated properly, Lordship. In the learned trial court also, in this court also, in earlier occasion. So, I'm all this, Lordship. In my opinion, this communication has been communicated with proper and legally, Lordship. And in Darshan also, it has been, Lordship also aware of it, that the prejudice has to be explained by learned friend. How, what prejudice she has occurred, Lordship. I have completed my opinion.
Only one, because he has, in fact, he has helped my case in two ways, my lord. He says that about some Article 19. My lord, to whatever little I have read, my lord, Article 19 is freedom of speech. It has got nothing to do with right to life. Then, na apuni Article 19 koisile,
Fundamental right.
it is being video streamed. You can check your submission. Then he said that the accused, he is giving the burden on the accused, that the accused should know something called as Section 47. Accused should object. Accused should know something called as Section 48. My lord, if this is how my friend have understood the mandate of law, my lord, I have got no submissions to make, because I have showed, my lord, it is squarely on them to demonstrate with cogable evidence that it was communicated. And then, my lord, that he has not, that there is an order of the magistrate that it is complied. My lord, with all respect and humility, my lord, at times, my lord, there are certain routine exercises which are done, my lord, at the lower judiciary level, my lord. Some, my lord, not in every cases, but in some cases I have seen. Some 48 notice, they have seen that the headline is notice under 48. Probably inadvertently, the learned court will have not gone into the body of the notice, that it is not to the relative, it is to some police and it is some blank 48 notices. Just headline, that notice is also there here also, your lordship may peruse, that notice is there in the record. I have flap marked it. That notice, these are, one notice is blank, absolutely blank, two, nobody's name. And the second notice is, it is not even a notice, the second one. The second one, in fact, is a WT message. So probably by looking at that, say right, but that would not amount to compliance, because if those notices are there in the record, it is for your lordships to peruse. Your lordship will see that those notices, there is nobody's signature. And one more thing, my lord, which he has said, that in the first bail application, my lord, the first bail application was not filed by me, number one. Now, my lord, if a counsel inadvertently fails to take a plea, will it disentitle a accused who is behind the bar of his right guaranteed under Article 21? I think the answer is a loud no. A counsel may not have taken up. If she would have been so expert in all Section 47, 48, 49, my lord, then why, my lord, we are practicing in court, my lord? My lord, evidently, my lord, there is an absolute non-compliance, and all this striking balance and everything, these are being discussed in Vyan Kumar, Pukaista and everything, my lord. Those are immaterial. You respect Article 21 and then do your job. That's simply, my lord, the mandate of law. Because, my lord, Article 21, nobody should be deprived of his life and liberty except a due process of law. Now, the process has to be followed. Clearly, my lord, 48 has not been complied with, my lord. And 1 year, rebuttal or sub-rebuttal? And my lord, yes, that it is, even had this been in Assamese, she would not have understood it because she is an illiterate giving father. My lord, if it is written in Assamese and it is explained to her in that language, at least to write it in Assamese, explain it in Assamese, because the burden is on you. The burden is not on me. That is what the Supreme Court says, my lord. It is not what Mr. Biswas is arguing.
Last, I wanted to state that, Lordship, I am not stating that the burden is on them. I am just stating that, Lordship, if I have to clarify that whether it has been communicated or not, I will not be able to communicate, confirm that without looking into the entry, Lordship. And I am helpless, I am handicapped in that sense, Lordship, because there is nothing in the entry, in the what I have found, Lordship. I am only stating that. I am not shifting burden. I know very well know that the prosecution's burden is there, because I have also read the judgment, Lordship. That is the thing, Lordship, the whole crux is that I am stating that I cannot confirm at this point of time by looking into the available material. It is my submission, Lordship, because I cannot go into the entry. That's all, Lordship.
I'm deeply obliged. I'm deeply obliged.
That's all.
Sorry.
Please, your lordship, this is an appeal on quantum, lordship. I'm willing to deposit 50%, can be withdrawn.
50% has already been,
Lordship?
you have already deposited. Or
No,
this is
I'm
first
willing
time
to
you had
deposit,
it on
Hmm? 8 to 9.
MSC to pick hard instrument, the learned for the then appeal.
The owner and driver will not be required here, purely
Pardon?
quantum. Service and owner and driver,
Huh.
they're not required basically, I purely on quantum. Can it be dispensed with us? Selling service only
No, we're
to,
going to admit the appeal, but notice has to go later stage. It's up to you. You can strike out the name. Claimant is only one.
One.
Number one is the claimant.
yes,
So it's an appeal under section 173 MB Act against the judgment and awarded date 11/09/2025 passed by learned member MSCT Sonitpur in MSC case number 96 of 2024 bracket of D under section 166 of the MB Act. It is submitted by Mr. Goswami that basically the case is of the appeal is
yes.
admitted to notice to the to all response to speed and impaired process, also called DCA. This matter accordingly up to 4 weeks as on a date to be. I to take you by Mr. R. Goswami, the learned counsel for the applicant applicant. This is an application under 41 Rule 5 CPC bring for stay of the operation of impugn judgment and award dated 11/09/2025 passed by learned member MSCD Sonitpur in MSC case number 96 of 2024 bracket of D. It is submitted by Mr. Sami that the connected appeal has been filed challenging the quantum of the award. However, they are ready to deposit 50% of the awarded compensation, subject to stay of the execution of the impugn judgment and award as stated above. Next, considering the submission made by learned counsel for the applicant appellant, the operation of impugn order and award dated so and so passed by learned member so and so is hereby stayed till disposal of the connected appeal, subject to payment of 50% of the awarded amount within 6 weeks. With the above observation, the present I stands. We are not passing the order of disbursement and delete the appeal.
Yes. Problem, Lordship.
After some time, Lordship, my senior is only another go.
খালি খালি লাগিছে আমি তাৰ ভয়তে
There, my lord, we have filed one restoration petition.
is what is the delay here delay
Delay for filing resolution 190, 4 days delay, my lord. Because
is you are appearing for whom?
Lordship, I'm appearing from respondent.
All respondents?
No, only sole respondent. Lordship.
sole
All
respondent.
respondents.
But Lordship, we have not received the copy, Lordship.
I'll give the copy, my lord.
And in regards to condonation of delay, do you want to submit anything?
So we have to need copy, Lordship, because. we
Oh,
have
Or you have
received
not
the
received
copy.
a copy?
Yes, Lordship.
Yes, ma'am. You can propose the query to the High Court. Yes, ma'am, Dilita. Phone number to phone number.
Internet council. Applicant, applicant. So, right. You are Mr.
Ek Kakoti, Lordship.
Appearing for the sole respondent. The present application has been filed under section 5 of the Limitation Act for condonation of delay of 194 days, including the and for restoration of the recalling the NEC appeal number. And again, and number to be spot on. Section number, restoring only recalling the connected MSA. And it is submitted by Mr. Kakani. They have not provided which the copy of the application, we filed their application. In view of this, the applicant is hereby asked to provide the copy of the present application. And rest of the matter may accordingly be listed. If we can list it after 2 or 3 weeks, in that case, we are not going to fix any date. Or if you insist on that, then it will come on the month of March.
Lordship.
After 2 weeks, we'll do.
2 weeks, Lordship.
After 2 weeks, as a date to be fixed. And further, the applicant is directed to provide the copy of the petition, the application during the course. She will provide it.
Lordship.
Today itself, ma'am.
Bless.
Video.
Lordship, there is an IF for delay 129 days, Lordship. Respondent number 1, 2, and 3, the claimant respondent, they are appeared, Lordship, and their name was shown in the cause list, Lordship. On the other hand, 4 and 5, owner and driver was not appeared.
So for 4, it has already been returned
Yes, Lordship.
with a report. The answer notice is already returned with a report that the not found returned to sender. And 5, we are awaiting.
Everything, Lordship.
So in case of 4, you have to take precedence.
Press ticket.
Mr. A. Kakoti, the learned counsel for the applicant appellant. From the office note dated 2/2/2026, it is seen that the learned counsel for the respondent number 1, 2, 3 had already entered into appearance by filing their wakalatnama. However, the notice returned unserved to the respondent number 4, and service is still awaited for the respondent. Next paragraph. Accordingly, the appellant is hereby directed to take fresh steps on the respondent number 4 in his present and proper address. Please do matter accordingly after 2 weeks as on a date to be fixed by the ministry.
Bless.
Here I am appearing for the respondent number 1. So for respondent number 2 is concerned, we'll file an wakalatnama today. And I've been served with a copy of another affidavit, additional affidavit by the petitioner. I need to take some instruction, Lordship, whether he want to file any reply or not. Respondent number 1. Lordship, may I kindly give us 2 weeks time
For the appellant side, they have not appeared here.
My brother is there.
You are for the appellant?
Yes, madam. Item number 9, Chola.
No, not 9.
11.
Oh, 11. Sorry, madam.
9 দেখুন ভুল গেল এও appear করলো কাকতি 9 to 1 Mr. Kakoti
Kakoti appeared.
he
I
appeared.
have sent it.
Yes, 11 the appellant side is not here. And
Thank
therefore
you,
you
Lordship.
want the
Sir,
copy
Lordship,
of
want to
the
take it up.
additional affidavit.
They have served us copy, Lordship, just now.
Copy of the additional affidavit.
Additional affidavit. So I need to take some
But we
instructions.
don't
from
know
the-
additional affidavit whether it is tagged with the record or not. আহিছে জানো?
I think they have just filed it because the copy has just been served to us. That might
Or
be
it
tagged with
is
the record.
till now it has not been not with the record.
I pray for 2 weeks time, Lordship.
Otherwise you are appearing for who?
I am appearing for respondent number 1.
1.
Today I will file wakalatnama for respondent number 2. Just now you have given me the wakalatnama.
Okay, then as a whole, how many?
2 respondents.
Two.
2 respondents.
Non appears on call, 11 number 2. Non appears on call for the appellant. Heard Mr. A. Bhattacharjee, the learned counsel, appearing for the respondent number 1. And it is submitted by him that the wakalatnama for the respondent number 2 will be filing today. Further, he submitted that one copy of the additional affidavit has been furnished to you, furnished to him, but on perusal of the record, it is seen that the same as not yet tagged with along with the record. Mr. Bhattacharjee further submitted that he will also take instruction as to whether any reply is to file against the
I will seek an
additional
instruction, Lordship, if it is required. Otherwise,
instruction as to whether the any reply will be filed against on the additional affidavit. List the matter accordingly after 2 weeks as an edit. After 2 weeks, 3 weeks will do or 2?
3 weeks, as the Lordship pleases.
3 weeks as an edit. Okay.
Diplomat.
I'm appearing for the sole respondent.
All services already completed.
Service has been completed once my learned friends appeared. My name has not been shown in the policy.
Yes. So, the record was called for or no?
No.
Required record not?
It is not required, Your Lordship. This is a transfer application, matrimonial matter.
Yes. Heard Mr. You are Mr. N. Sharma.
Yes.
Heard Mr. N. Sharma, the learned counsel for the applicant, sorry, petitioner. And also heard you are Mr.
A. Kabra.
A. Kabla. Appearing on behalf of the sole respondent. However, the name of the council, learned counsel is not reflected in the cause list, and accordingly, the registry is hereby directed to reflect the name of the learned counsel for the respondent in the next date of listing. Services accordingly completed. Admission column we can list it. You want any date
To
here?
file affidavit.
You want to
for which
file affidavit.
For which time?
But it is submitted by Mr. Kapla that he needs, how many weeks you need?
6.
6 weeks.
He is residing in Bangalore.
Take 4 weeks. Try to take instruction.
Okay.
At least 4 weeks time to file his written opposition. Prayer is allowed. The matter will be accordingly listed after 4 weeks as on a date to be by the registry, enabling the respondent side to file their written opposition. Presently, where it is pending? Presently, matter is pending where?
In Guwahati.
Guwahati.
Guwahati. Now we want to. take it
Petitioner is from
transferred-
Udalguri.
It's from Udalguri.
Udalguri.
It's a matrimonial.
Matrimonial. Husband filed, the respondent filed divorce case against petitioner. So as I am residing there, I am the original date of birth from that particular place.
So I need to transfer this application to there. And in the meantime, I had also filed an application on the DB Act that is also pending there in Udalguri, and the respondent has already appeared there.
So your stay was operating, I think.
Yes, Your
Interim will continue till next year. What is your problem? He can come to Guwahati. He can come.
I will take instance. Deeply.
May I please, your lordship?
Yes.
Lordship, the petitioner before your lordship is Tinen. He has been in the suit premises since the last 30 years. And initially he was under Mathura Prasad Sahu. After his death, he came in tenancy under J. Narayan Sahu. And after his death, his children became the landlord. Lordship,
No, that will come later on. What is the stage position?
Lordship stage is that they have already, their name has been shown in the cause list. They have already appeared. Lordship,
How
the
many
issue is
respondents are there?
only single
Sole
respondent.
respondents.
But Lordship, what issue is that on 10th of February, the date is fixed before the lower court for deposit of challans for police, cost of the police challan, because they are going to execute it. And I am in the suit premises since last 30 years. And I am already 64 years, already, Lordship. So at this stage, if I am been evicted, this CRP
That
will,
order column, they have not appeared here.
Lordship, only some protection may be given, because on
Without
10th,
hearing, we cannot.
Lordship, on 10th, they are. It is a date fixed for submission of challan of the police, cost of the police, because they have already appeared. They are not
File a
appeared.
petition under 4700 or 96, whatever, before the learned trial court.
Lordship, on the first week of January, a petition was filed that this produce the order of this honorable court, and that is why we have mentioned this matter and we have voted, because it was not listed, although they appeared in the month of December itself. Because otherwise on
There is
10th.
an order column.
Lordship, some protection till the next date, let them appear. After 1 week,
We
it
are
may
not
come up
without
after
hearing. How
1
can
week,
we
because
how can
otherwise
the
on
order
10th, if I
get
have evicted, it will become
The
infectious,
first
Lordship.
of hearing, that order prepared maybe could have been made by you only.
Because Lordship,
Mr. J. Khandeval,
may I submit, Lordship?
applicant.
Lordship, if
Appears on call for the sole respondent, though names of 2 counsels have been reflected in the cause list. Your matter is fixed on 10th,
yes,
and so in that case, we don't have any time. Let it be on 9th then. Okay, Monday we are listing.
Lordship, much obliged, much.
Can you try to, oh, yes, you are here.
No, Lordship, and in item number 11, Your Lordship, I was next port number 11, port number 8,
It
Your
is
Lordship.
already passed.
My name will be recorded in the
Already passed.
Lordship.
No such adverse order is there, simple order.
But we have filed an affidavit that has not been on record,
It is not on record.
not a record. That is why matter be taken on fix on any date, Your Lordship.
It is already, order is already passed.
Lordship.
Much obliged, Lordship. May I please, Your Lordship?
My lord, in this matter, I am appearing for respondents. And I have filed my wakalat number yesterday, my lord.
Yeah,
Matter
the
is
respondent,
different.
1,
Yeah,
2, 3.
my lord.
There are 3 respondents only.
No, Lordship, there are 40 different defendants also, Lordship.
Huh?
1A to 1F, Lordship.
1,
There
8,
is office note dated 4 to 26, Lordship.
1, 8.
So there it has not been served on 1A, 1B, 1C, 1D, 1E.
Regarding 1D to 1F, there
1F.
is office note that AD card has been returned with illegible signatures here.
So now implemented respondents are 1A to 1F.
Lord. The service may be awaited for respondents 1A to 1C. His AD card is not returned. Lord.
Do you have any instruction, Mr. Chaudhary?
No, my lord. I have instructions only in respect of 1, 2, and 3, my lord.
So how this one A to one F be, I mean, substituted, whether they are substituted every
Lordship, they are performer defendants. But they have
In the suit,
performer,
in
then
the suit,
how one A to one B?
I-
If they are performer, suppose their, I mean, serial numbers ought to have been after 3, 4, 5, 4,
4A,
whatever.
4B, 4C.
in the suit
Whatever.
itself, my lord, there were only 3 people. In the suit, my lord,
Ah.
the lordship will find the plaint at page number 26,
26.
6. There were 2 plaintiffs and there were 3 defendants, my lord.
Yes.
Now against my lord, whom they have brought in, my lord, all these people.
They-
we do
How,
not know.
how they one A,
In
one
this
B?
case, I am led by Senior Counsel SK Singh, Lordship. So I do not have the brief today, Lordship. In the morning, I was instructed to appear.
And say that,
That is the difficulty.
let it be listed on some
If
other.
they are supposed performer also, they should come.
4A,
Why,
4B, 4C.
whatever, but why one A, one B? Generally, what happens? We numbered like one A, one B, one C. If suppose you have to substitute one,
One.
they may be the legal layers or they may be somehow related. But if they are the profound respondents, then how one A, one B, one C?
Lord.
I mean, there may be a confusion in that regard also. Anyway, you have already appeared, no?
Yes,
one,
For 1, 2, 3.
1, 2 and 3 I have appeared.
And see the though the return on service, but
Eligible.
the signatures are very illegible. It's not legible signatures. Service report is not yet come. We can have it for them. By which order you have them as a performer?
My lord, if they are to be taken as performer first, they will have to be added as performer in the suit, my lord. Only then, my lord, it can be taken as performer here. In my respectful submission, my lord, these people are not performer defendants in the suit, my lord.
Ah, you have already shown.
Yes, madam.
So he may not be in a position to say
Because
that.
short date may be fixed, we will clarify, Lord.
They are not made performer in your original case. You are Mr.
A. Dhanuka, Lord.
Hard Mr. A. Dhanuka, the learned counsel, appearing on behalf of Mr. Singh. Also heard Mr. G. Chaudhary, the learned counsel, appearing for the response number 1, 2, and 3. However, from the office note dated 4/2/2026, it is seen that service is still awaited for the response number 1A, 1B, 1C, and the ID card which has been received back for response number 1D, 1E, and 1F are also not with some illegible signatures. Let the service be awaited for all the performer respondents number 1E, 1B, 1C, 1D, and 1E, and 1F. ভাকালে লিখি দিব সার্ভিস রিপোর্ট করো সার্ভিস রিপোর্ট এটার রিপোর্ট আহা next para Mr. G. Chaudhary, the learned counsel for the respondent submitted in this regard. Then the original suit, there are only 3 defendants. That is the defendant number 1, 2, and 3, and there were no performer respondents were there in the original suit, and hence she submitted that without any impediment of the performer respondent in the original suit. How the performer respondents number 1A to 1B F is implemented in the present case. let the matter be accordingly listed. How many weeks you need here?
2 weeks, Lordship.
4 weeks. 4 weeks as an date to be fixed by the registry, and the issue raised by Mr. Chaudhary also may be heard accordingly. That we'll hear the matter.
What's the interim order passed earlier?
Interim was there.
Procedurally, he refers an adjournment, my lord. He did not say it, my lord. He came in an indirect manner. By order dated 19/12/25.
Interim already interim granted dated 19/12/2025 be continued till next date of listing.
Much of that.
Yes, 15.
May it please, my lord.
Yes.
My lord, we had closed this honorable court under 227 against the order and judgment dated 4/1/25 by the learned additional district judge Hailakandi directing payment of so and so with 6% interest to respondent number 2. This is under the Indian Telegraph Act section 16 subsection 3 of the Indian Telegraph Act, to be more precise. What has happened, my lord? Notices were issued to all the parties, but the AD card of the private respondent has not been returned yet.
So you're representing
Yes, my lord. Private
private respondent.
respondent number
Oh, you have already appeared.
Yes.
Proper respondent number?
2, my
Respondent
lord.
Huh?
2, my lord. Respondent number 2.
2 is the private.
Yes, my lord.
Service is complete, my lord.
In that
My-
case, service is completed.
Complete. My records had been called for.
So you're for the state respondent?
May I please, Lordship? I am for the state respondent. Lordship,
Yes.
ordered at the 19/12/2025.
Yes.
A query has imposed upon the whether the article 227 section 115 of the CTC is applicable in this. matter.
That it be that
That
on
was
issue.
imposed. That query has been imposed upon the.
Yes, yes.
My lord, I will file a short reply, my lord, on the maintainability of this petition, my lord. Next day.
So otherwise it has been filed under 227.
227. There are other batches of writ petitions that have come, but then filed under 227 and has been entertained by this honorable court. But I shall satisfy my lord on the legal aspects of how Article 227 comes into play. There's no provision for appeal in this. Under the order of the district judge under section 3 of the Indian Telegraph Act, there's no provision for appeal or division.
16.5 finally.
16.5, my lord. Section 16.5 also. So I shall satisfy your lordship on the next. Then interim orders may continue. Interim orders have been.
Heard Mr. Arsha, the learned senior advocate assisted by your Mr.
And Kiram.
and Kera, the learned counsel for the petitioner, and also heard the government Gogoi, no? Yeah. TR Gogoi, the learned government advocate for the appearing for the state respondent number 1. And you are Mr.
AHMR Chaudhary.
AHM R. Chaudhary for the respondent role to private respondent. Services accordingly completed. However, it is submitted by Mr. Gogoi that on the last date, that is on 19/12/2025. There was a query as to whether the present case is maintainable under Article 227 of the Constitution of India, or it has to be filed under Section 115 of the 115. In that case, Mr. Chaudhary, the learned counsel appearing for the respondent, as well as Mr. Sharma, the learned senior advocate, also submitted that they will argue on the point of maintainability. let the matter be accordingly listed. Do you want any fixed date here?
Yes, madam. After 2 weeks.
After 2 weeks, any fixed date? What?
First week of March or last week of February, whatever, whichever is convenient to my lord.
Let us see first week of March. 6th of March will 6th of March, interim be continued till next date of listing.
All right.
May please, Your Worship. In earlier occasion, the Honorable Clerk is directed to registry to obtain instruction regarding the service of notice.
Government works.
Government, seven. Respond number 1, we have taken step. But
So
as
government is respond number 1 or what?
1, 2 and 3 are government.
2 and 3 are also government lords.
2 and 3 are.
Lords.
No, in regards to one, he is after 14 Boda. How government is instructed? I mean, I don't know how you're related with 1. 2 and 3 you were government respondent. Now
Lords.
One is a private restaurant. Actually, my lordship, dispute between the petitioner and respond number 1 regarding the land dispute between the.
who is asked to take necessary instruction? By 2.
We have taken step.
Ah.
Registry, the Honorable Court is directed to registry
Acha.
regarding the obtain instruction whether the service is complete or not. As per official, the notice was delivered, my lordship.
But main dispute is between 1 and the petitioner and respond number 1.
Yes, my lordship. As per my instruction, respond number 1 address is changed, my lordship. So I want to file an IA for including substitute the post title, my lordship.
Substitute post
Yes, my lordship. Amended post title
regarding his address.
present address of the respond number 1.
So that would be better. Otherwise, he is the one from against
Okay.
the 2 and 3, the state only. There
State
may
only.
not be any. Heard Ms. R. Beckham, the learned counsel for the petitioner, and also heard Mr. T.R. Gogoi, the learned government advocate, appealing for the respond number 2 and 3. From the office note dated 4/2/2026, it is seen that the registry has already obtained the track consignment report and for where the syntax notice was delivered. But it is submitted by MS Begum that as per her instruction, the petitioner number 1 is not residing in the earlier address. And she already obtained the new and present address of the respond number 1. Accordingly, she submitted that petitioner may be allowed to take fresh steps on the new and present address and to amend the cost title of the petition. In view of this, in view of this, the petitioner is the prayer full stop, the prayer is allowed. Accordingly, the petitioner is hereby directed to take, file, additional affidavit or oblique interlocutory application for amending the cost title of the present petition by inserting the new and present address of the respondent. How many weeks you need here?
1 week, my lord.
1 week, but after 1 week, we cannot fix a date. After 1 week, it will come.
Yes, my lord.
After 1 week, as on a date to be fixed by the date. So either you file your additional affidavit or through an interlocutory
Yes, my
or
lord.
as per your choice.
Yes.
By putting or inserting the new address.
My lord said there is an interim order.
Interim was there, interim be continued till next day.
Obliged, my lord.
One now. Time now. Time now. May I please allow, sir? Application for delay continuation, my lord.
What was the delay?
My lord, delay is, my lord, 1700, my lord, days.
Yes,
It
you have
needs
already
some-
appeared.
It needs some time to.
My seniorism there.
Huh?
My seniorism there. I'm appearing for respondent number 1.
Maybe listed any other hearing day, my lord. It will take some time for hearing. 1760 days. There are so many, my lord.
Acha.
Any other hearing day, if you lost it. Date may be. fixed,
You
my
are
lord.
for 1 and 2. You are
Sir.
appearing on behalf of MS Chaudhary.
Yes, ma'am. Service is complete, my lord. No hearing.
You are Mr.
T-Shake, my lord.
T. Sheikh. Heard Mr. T. Sheikh, learned counsel for the appellant applicant and also heard. Here,
S as well.
as Advi appearing on behalf of MS R. Chaudhary for the respond number 1 and 2. It is submitted by MS Azmi that they may file the objection against the present application, interlocutory application. Let the matter be accordingly in hearing day, na?
My lord, any other hearing day, my lord?
Hearing day given
Yes, my lord.
26th of March will do,
My lord.
26th. That is hearing day, you will hear your submission.
Highly obliged.
Lordship, they have filed a IA for withdrawal, but in this case, Lordship, we are alleging fraud. Because we have insurance company proved the FIR as well as the final report. Final report was submitted. And in that, Lordship, in those, her name does not appear that she was injured in that. Agasti Phukan was injured, that we are not denying. But this Rishma Phukan was. So, Lordship, the LCR has come, so we can hear the matter finally. And amount is also very high, 46 lakhs something.
In fact, my lord, in the judgments also, her name has been recorded as Agasti Fukon or Isma Fukon, alias. And in her evidence also,
Alias?
yes, Agasti Fukon alias Isma Fukon.
So, Lordship,
That was recorded.
really, not that-
And in evidence on affidavit also, her name has been recorded similarly.
No.
So what is the dispute? If she is alias or alias, jo Prisma alias Augusti, then
Lordship, that is not in the FIR or the in the final report. If it is alias, it will be in every document. In the FIR, she is not mentioned in the, they have, that alias is Lordship is the afterthought. That is what, so Lordship will finally hear it because the amount is also not small. It is for an injury case, the compensation granted is 42 lakhs 99,836 injury case. So Lordship, since the LCR has come, Lordship, finally the case can be heard any date. I'm ready with.
My lord, memo of appeal is yet to be served upon us.
Sorry, notice put here. That's how you came.
Now,
Service complete, we said.
if
On
I-
one.
one.
মই দিম বনাই পেলাই মোক return
And
কৰি
what is the position of the main case?
Lordship,
Where the service is
office
completed?
note- Yes, Lordship, office note dated
That
20
will be-
29/1/26 মোক কপিটো বনাই পেলাই ৰিটাৰ্ণ কৰি দিলে।
I like that. কিবা ঠিক কৰি আছে। আচ্ছা ঠিক মই মানে অফে কৰিম নালাগে এচি
Office note dated 29/1/26 Lordship. R1 file wakalat number. AD card for respondent 2 and 4 not yet received back to Lordship. The registry will verify the postal receipts Lordship. And for 3 Lordship, insufficient address. Step 3 is insurance company. SDF,
You have already appeared.
you are appearing.
Appearing for 3. MSc appeal to look at part RD Mujumdar Dilan and Constable. Most hard. You are Mr.
B. Burman.
B. Mormont, Dilan and Constable appearing for the respond number 1. And MS, your M. Chetia. M. Chetia, the actually appearing for the respond number 3. From the office note dated 29/01/2020, it is seen that AD card and the service report on respond number 2 and 4 has not been received back. In view of this, PST is hereby directed to track the consignment report of for the respond number 2 and 4 and will report for takeoff. HA has already been received, matter is already admitted. Let the matter be accordingly listed after 3 weeks as on a date reviewed by the PST. Next paragraph. Next, ISO and suspense. Heard Mr. Bormon, Delan Council for the applicant respondent, and also heard MSRT Mujumdar for the respondent. This interlocutory application has been filed seeking permission to withdraw the 50% of the awarded amount along with 9% interest, which has already been deposited before the date. Next paragraph. MS Mujumdar, the learned counsel for the appellant submitted raised objection and submitted that they have alleged brought the allegation of fraud against the present petition, and accordingly it is submitted that as share has already been received, matter may be finally heard and decided. In view of this, the IA may be taken up or along with the connected MSc appeal for hearing. List after. We're listing it after 3 weeks. We cannot fix a date here.
Clear.
That's good. 20, yes.
Well, actually, the matter has come up for the first time. There is a delay of 35 days.
How many days delay?
35.
35 days. IA to the IA 233. Hard as M. Setia, the learned counsel for the appellant, applicant. This is an application on Section 5 of the Limitation Act for condoning delay of 35 days in preparing the connected appeal against the judgment and order dated 29/07/2025. Issue notice to the respondents through speed post and usual process. The applicant will take steps within 7 days. List the matter accordingly after 3 weeks as on a date reviewed by the district. Okay, you take steps.
Yes, my lordship.
Hearing to assent.
May it please your lordship. Lordship, there is a delay of 23 days in this case. So if it can be
The first time.
first time, lordship.
Well,
No, if it can, because lordship, what has happened is in the meantime, I have received a Bakijai notice. This is the notice, lord. Fixing 28th February, giving real 20 days time to even respond.
28 people,
20.
20.
No, so if the delay is condoned, then maybe I can comply. I will immediately deposit 50% before that time.
The persons are from where? Which district?
Jorhat.
Just 16. 16.
Yes, sir. 16, in that case, I'll be allowed to take steps by Dusty also besides registered. I'll try to get the Dusty service completed before 16th. Lordship,
16. 1 6.
1/6.
Yeah.
16th. Publisher. By Dusty and
Yes,
registered.
Dusty is also allowed.
Publisher.
May it please your lordship. Your lordship, this matter has come up for the first time. There has been a delay of 28 days in filing the appeal, your lordship.
27 days.
Lordship, here in this case,
Agarwala
claimants
is
have
appearing for all the claimants.
Yes, Lordship. I don't have any objection. Delay may kindly approval.
appeal is on quantum, your lordship.
Pardon, it's before the court and counsel for the applicant appellate also heard Mr. R. Agarwal, the learned counsel appearing for. Your claimant respondents are 1,
1,
Two,
2, and
three.
3, your lordship.
1, 2, 3. Claimant respondents number 1. This has come for the first time.
Last time, Lordship, I
Lordship,
got
it's
delay,
come up.
Lordship, I don't have any objection. This is-
No. You have appeared? How?
Yes, yes, yes. As a capital, I will.
It
Yeah,
has
we
come
are
up for the
working.
first time, your lordship.
As capital.
So can be where you have explained your delay?
Lordship, in para number 2.
Para 2.
Para number 2, yes, your lordship, page number 5.
Transfer for the claimant respondents an application on section transfer for the delay of 28 days in preparing preparing the connected appeal against the judgment and awarded 3/4/2025 was by learned member MSCT number 2 in MS Kamrup Metro in MSC case number 2157 on the 2. Next part is submitted by MS Bhattakur that the delay that due to only for observing some official formalities and to obtain the certified copy of the judgment, etc. There is a delay of 28 days in preparing the connected act. However, there is no intentional laches or negligence on the part of the applicant appellant in preparing the appeal with a delay of 28 days. As he further submitted, the delay has already been explained in para 2 of the petition. Mr. Mr. Agarwal, the learned counsel appearing for the respondent claimant's respondent raised no objection and submitted that he has no objection if delay of 28 days is continued. Next para, considering the submission made by learned counsel for both sides, comma, the grounds mentioned in the para 2 of the petition, which are considered to be reasonable and justified ground vis-a-vis for the ends of justice. The present application, interlocutory application is thereby allowed by condoning the delay of 28 days and preparing the connected registrable. In view of this, registrable to the needful in registering and numbering the connected appeal and to list with the above observation the highest justice.
My name may kindly be shown.
Name of Mr. A.R. Agarwal may be reflected in the call list at it while listing the connected appeal.
Date you may kindly fix for an admission. Next week.
Okay, to discharge COVID.
Oblige it.
3 weeks COVID. Okay. It will part. It will give us. Oh, I tell you. Yes.
Made by the Lordship. Lordship is IAS for condoning the delay of 140 days in preferring the matrimonial appeal, Lordship.
So this has come for the first
For the
time.
first time, Lordship.
What is the delay you?
Delay 140 days, Lord.
140 days. Mr. Assessing the learned counsel for the applicant appellant. It's an application under Section 5 of the Limitation Act for condoning the delay of 140 days in preferring the connected mat appeal against the judgment and order dated 30/04/2020 passed by the learned district judge Udalguri entitled suit bracket D number 62/2020. Issue notice to the sole respondent. To the sole respondent to speak through speed post and list the matter 3 weeks will do.
Lordship.
List the matter accordingly after 3 weeks as an edit.
Obliged, Lord.
May I please? My lord, in this case, my lord, the order that appeal against is, my lord, 10/9/25, my lord. I applied for certified copy on, my lord, 15/9/25. I got it, my lord, on, it was ready by 19/9/25. So, my lord, 5 days has been taken obtain certified copy. My lord, it ought to have been filed on, my lord, 14th of December. But since 14 was, my lord, Sunday, so I filed on reopening the 15th, my lord. But the office reported that there is a delay of 2 days, my lord. In fact, my lord, there is no delay. If the reopening day is not counted, then there is no delay.
Reopening day was?
Reopening, my lord, 13 was Saturday, second Saturday, my lord. Office was closed. 14 was Sunday. So on these 2 days, my lord, there was a holiday.
So your
I was to file it on 14, my lord.
If it is filed on 14th.
My lord, if it is filed on 14, then there is no delay, my lord.
So now you have filed on 15th.
15. So the office says that there is a delay of 2, so I filed a application, my lord, convenience.
Heard Mr. J.C. Gaur, the learned counsel for the applicant appellant. This is an application under Section 5 of the Limitation Act for condoning the delay of 2 days in preparing the connected appeal against the decree, judgment and decree dated 10/05/2025, passed by Learned Civil Judge Senior Division number 1, Kamrup M. Guwahati, in music case number 432/2025, arising out of TS 289/2025, rejecting the prayer for temporary injunction. It is submitted by Mr. Gaur that the case was filed within within the period of limitation. No, the case was within the submitted that within the period of limitation, the cause ought to have been filed on 14th of December, na?
My lord.
14th of December 2025, as it was a Sunday. The appeal was filed on 15th December 2025. However, the registry had calculated that there is a 2 days delay in preparing the appeal. Mr. Gaur further submitted that even if there is a delay of 2 days, there's no intentional negligence or laches on the part of the appellant. And there may be some wrong in calculation for which the delay is accordingly notified by the registry. Next, considering the submission made by the learned counsel for the applicant and also considering the number of delays, the present interlocutory application is allowed, condoning the delay of 2 days in preparing the connected appeal against the judgment and against the decree is not,
It is
it's
a
an order, I think.
Order.
It is against the order dated so and so, passed by so and so, in means so and so, in connection with so and so. With the above observation, the IS stands disposed of. The registry is accordingly directed to register and number the connected FAO.
Okay.
My lord, in this matter, I am appealing for the respondent, my lord. I am the holder of the award, my lord, which has been passed in my favor. It's, my lord, litigation drafting probably, my lord, continuing since 2009, my lord.
So
Section
all
30.
these IS are connected.
All these
out
dials
of-
are connected. All the dials are connected, and 2 points, my lord, my learned senior friend is here, my lord. He will say, my lord, after dismissal of the petition under section 34 of the Arbitration and Conciliation Act, an appeal has been prepared under section 37. The appeal was also dismissed, my lord. Ultimately, my lord, when the appeal was dismissed and we had, my lord, filed a petition for executing the award, my lord, that was just thought to start again after this prolonged litigation and all, my lord. Then they have come up with this picture saying that, my lord, that person, DL Agarwala, that person who was the contractor, my lord, has not been substituted. Now, it was all around, my lord, our stand that DL Agarwala was the name of a firm. Now, my lord, taking that view again, they have come up before this court for the purpose of reopening, my lord, that case which was already disposed of. Now, this court has to see now whether after disposal of an appeal under section 37, by dismissing it, my lord, whether at this point of time, it will be again liable to be opened, my lord, on the basis of what has been stated in the IA. And, my lord, then secondly, my lord, in these IAs I have seen, my lord, they have, my lord, made a prayer for stay of the further proceedings in the execution. Now, your lordship is aware, my lord, for the purpose of staying execution of the, my lord, money award, my lord, the provisions of order 41(5), my lord, apply. Whereas they have nowhere stated that, my lord, they undertake to, my lord, secure that money, my lord, by way of either depositing the entire money, and because nowadays, my lord, after these I'll just give the citation. After these cases, my lord, in arbitral cases, at least, my lord. My lord, it has been established that, my lord, the entire monetary award is, my lord, posited. And, my lord, during the pendency of this litigation, this man, my lord, who was the beneficiary of the award, my lord, he died, my lord, with cancer, my lord, he could not treat himself. So at this stage, my lord, now, because these IAs have been filed, my lord, I think sometime, my lord, file my response to, my lord, application, finally grant this sometime, my lord, I'll file my response. And then this matter to be heard on that point as to whether, my lord, it is liable to be paid without, my lord, securing that decree, without, my lord, paying as per the money, order 41, group 5 of the.
My lord, I don't object
in regarding to the seeking time by my learned friend and my brother. But other part, initial part, definitely I'd like to vehemently oppose it at this stage, because I'm not sure for whom he is appearing. That should be recorded first, my lord. My respectful submission for whom he is appearing.
The record you can.
I'm appearing for the farm Mr. G.L. Agarwal. Right, that may be recorded.
Farm.
Or farm G.L. Agarwal.
Otherwise, in these IAs, the farm is there, and that apart, there are some other.
Yes.
So now, can you tell us in which IAs you are appearing?
In
In all eyes.
In all the eyes.
In the all the IAs, Mr. GL Agarwala is there.
G.L. Agarwala and in the farm, my lord, because on the death of G.L. Agarwala, this farm as a lordship note, it was a partnership farm.
Mm.
And the partnership farm has to be reconstituted.
Mm.
Thereafter, my lord, those whoever has been inducted into the partnership farm after reconstitution, my lord, I have appeared for all of them.
So he is appearing for all, I think.
So this may kindly be recorded. Otherwise, I have every doubt, with all respect, because the G.L. Agarwala died in 2019. Then he, 21, appeared in the appeal and submitted that we do not know. It is his duty under the established law and the Supreme Court ruling for the plaintiff to inform the court and the other party that my party died. That has not been done. But whatever it is, that is part of, but I accept that his prayer may kindly be accepted. I don't like to object it, but facts I will go in later part. Anyway, let my allow me to file my objection. Sometime I'll bring my objection to the court against it. Thereafter, and as regards his statement that he was not aware about G.L. Agarwala in Assam was not somebody who was a competition. That I don't care. Who is he? I don't care. You may not care. It is not for courts also. It is not that. Yes. But definitely. It is. The reason for making that statement is that it was so widely reported everywhere, in the media everywhere, that they cannot say that we are not aware of the death of that. So that is. Why should I? It is your duty legally to inform the court. That is all right. That is, you are bound by the law. You are bound by the settled decision. A farm doesn't die. It is you who submitted that one line, the learned counsel, Mr. Chaudhary, has submitted, that the respondent died on 31/1/19, and till today, no application for substitution, his legal heirs have been made. On my objection, I'll bring those on record, my lord. Will come. We don't like to waste valuable time of the court. I'll bring that on record, my lord. Let him counter that at that point of time. My lord, just my lord, taking this court for a my lord, misleading the court and my lord, denying my lord the award, my lord, which has been passed in my favor since 2009, my lord, this is 2026. My lord, why should I mislead? I am speaking from the record of the honorable court. What he has submitted is recorded. So what is the question of misleading? What stopped him from objecting at that point of time, my lord? Why didn't he appear, my lord? Why didn't he object? It is not that it was an ex parte order. He was represented on that particular day, my lord. Misleading is a word which is contemptuous. Why? I am not contemptuous. Because at this stage, after doing 53 years, nobody has said that I am misleading the court. That's all right. That is highly contemptuous on part of Mr. Gautam Chaudhary. I tell you, I'll take it very seriously. Yes. You'll face the music. Yes, I'll face it. Jobarot
J.R. Thakur. J.R. Thakur.
J.R.
You. No. Convenient to him.
Can there be a date, my lord? Let it be 4 weeks.
Let it be 4 weeks.
Only my respectful submission. In this cause list, I have not seen the name of Mr. Chaudhary.
We are going to direct the registry to reflect his name.
Yes.
Other registries here were directed to reflect the name of Mr. Chaudhary for the respondents.
Yeah.
Names have been reflected in some.
Names are, yes, in some items it will reflect. Yes, in some items it has been reflected.
Should, if I may be permitted, actually notices have not been issued in the others because there are two condonation petitions in each of the appeals. So,
Condonation.
two condonation petitions, one condonation for substitution of the legal S, one condonation for the restoration. So, if I am right, condonation.
But in all the IA, cannot they tell us the number of IAs?
Yes, I've marked the.
If she can give me, my lord, copies of all the IAs which have been filed, my lord, even if she gives me one copy each of all the IAs, my lord, I'll respond accordingly.
No, but you're saying that there are two IAs for condonation.
Yes.
So
there
please
were
tell
four-
us the number.
Yes, I'll tell. IA 2667 of 2024, item number 30.
Yes.
I have already made it. And that is in arbitration appeal number 11 of 2015. Next page, it is IA number 4 of 2025. Other page. Next. Has the lecture got it?
Is these two IAs are for condonation?
Condonation. There are 4 number of arbitration appeals before your lordship. In each appeal, there are 2 condonations. Condonation for substitution and condonation for restoration. We had been asked by the registry to file 2 separate condonations. One for restoration of the appeal, which had got abetted, and another for substitution of the legal heir. So each appeal has 2 condonation petitions, respectively.
And what are the other IAs?
Other IAs are mainly for stay.
Stay.
Yes. And for restoration and for substitution.
So in that case, if it is not yet restored or your delay is not condoned,
yes,
then those arbitration appeals which has already been dismissed or whatever,
yes,
is not yet restored.
No, lordship. That is the
That
problem.
cannot be
So-
taken up at this stage. If interlocutory application which has been filed now, first that will have to be, my lord,
condoned.
I mean.
Yes, obviously, these two petitions is to be heard first.
Yes.
Now you are saying that in every appeal there are 2 condonation.
2 condonation petitions. One for restoration of the appeal, condonation.
But now you have pointed out this item number 30.
Yes.
This is the in connection with arbitration appeal number 11.
11, correct.
So now what is the other in ISC bill 4/2025?
That is arbitration appeal number 10 of 2015. Condonation for substitution, that one.
Can I clarify before your lord? There were, my lord, there were, my lord, 4 appeals which were dismissed. Now, my lord, they have come up with not 2, but with 3 IAs each.
5 IAs.
3 IAs each. One IA is for, my lord, allowing them to substitute the legal heir whom the claim has died. One IA is for condonation of the delay by which the abatement by which that was dismissed, that is to be restored. Thereafter, they have filed another IA by which they want the further proceedings in that award to be stayed. Because
But there is delay in filing restoration also.
So first restoration
and condonation, that has to be taken care of. If that is taken care of, thereafter the
Then
appeals are
only,
taken on the
yes,
spot,
yes.
then only the question of stay and all these things will come.
These are all দিগদাৰ হৈ যাব এইবিলাক চব একেলগে কৰিলে অসুবিধা হৈ যাব তো একেলগে হ'বই তাৰপিছতহে ষ্টে আহিব
হয়
চব ৱেইট কৰাই দিছে কাৰণটো মিক্স হৈ গৈছে
বেলেগ বেলেগে হয়
basically
in
first
the interlocutory
problem
application for condonation substitution, that has to be adjudicated first.
no
Thereafter
even if substitution also has to be considered subsequently
Yes.
after condoning the
because
delay
appeal-
filing the restoration
Yes, ma'am.
then only restoration can be
Yes,
accepted and then substitution but
Yes,
now
correct.
they all are wait we are that's a confusing fact.
yes,
These
absolutely.
have to be segregated.
To allow for 4 weeks to know. So look further, considering the submission made by MS J.R. Thakur and Mr. T. Chaudhary, the counsel for the applicant and the respondent respectively, it is seen that there are some I's which are filed for the to condone the delay in filing the restoration in filing the restoration petition in connection with some of the appeals which has already been dismissed. And apart from that, there are some substitution petition, some I's which are filed for substituting the legal heirs to the deceased respondent. In the same time, it is also seen that the other I's are for praying for stay of the execution of the city. So accordingly, the registry is hereby directed to list the matter separately and separately when list the matter separately along with all the I's for each connected arbitration appeal. The next set of listing, the registry will accordingly clarify the matter and will the number the and will accordingly listed them. We are directing the registry to segregate. I mean, now see, you have submitted that one, this item number 30 is in connection with arbitration appeal
Number 11. I can
wherein
point out, yes.
wherein your condonation is also there and subsequently there may be one other
Yes.
IA for substitution also.
Uh,
That for the restoration also.
Yes.
So
So there
that
has
has
to
to be
5 IAs,
clarified.
Lordship.
Then only it will test. Suppose I am saying that suppose arbitration appeal number so and so with IA so and so so and so so and so. Arbitration appeal number so and so
Yes.
with IA so and so. In
Yes.
that case, it will be easier for our part
Easier.
also.
Correct.
Okay, otherwise we are listing it after 4 weeks. Let us see that registry will do that exercise also.
Yes.
Date may
Date you want date. Okay, date. Huh? In that case, you have to take on date on 11th of March.
Yes. And
Here, two appeals were there, Malak. One is this second appeal 217 oblique 2024 and other is 218 of 24. But what happened? The present appellant.
One more is 218.
Yes, Malak. What happened? This present appellant, Malak, entered into an agreement for sale with the respondent. And subsequently, agreement could not be executed. For that, my lord, the appellant filed a title suit for specific performance of contract. The learned trial court dismissed the prayer for specific performance of contract and directed the respondent to refund the amount, advance amount.
The alternate mode was allowed.
Yes, alternative prayer was allowed. Challenging the judgment and decree, defendant filed an appeal before the appellate court, and present appellant, earlier plaintiff also filed an appeal. 2 appeals were filed. So, my lord, in that case, appellate court, he did, appellate court did that plaintiff is not entitled for advance money also. So, my lord, the defendant's appeal was allowed, decree was modified, and present appellant's appeal was dismissed. So, challenging both the two judgments, 2 appeals were filed. Here today, my lord, 1 appeal is before your lordship, my lord. May I pray, my lord, both the appeal come together, my lord, because matter is same, arising out of same trial court judgment.
So in one appeal, they were directed to refund the amount.
Yes,
Repayment
in
of the
the
amount.
trial court
And
judgment.
About that order, against that order also they moved and
Yes,
appealed.
defendant was directed to refund the amount.
Ha,
So he challenged that the decree.
yes.
So his appeal was allowed. So the appellate court held that plaintiff is not entitled for the
Entitled to any-
advance money. So this case is that appeal against that judgment. And the plaintiff's appeal, who challenged the trial court's dismissing his prayer for specific performance, that appeal is RSA 218.
But Mr. Agriculture, return of appellate case was fit for hearing under CPC. But it is submitted by Mr. Rita that they have preferred one more appeal, which is being numbered as 218 of 2024, arising out of same judgment of the landed trial. In view of this, the registry is hereby directed to take or list the RSA number 208 along with the present appeal. In that case, so whether notice has already been issued or it is still for hearing on
Both are in same stage.
same stage for hearing on order 41.
Lovely.
We may not fix a date here. We
Well,
can be listed after 3 weeks. They demand
Or
to
2
be
weeks, ma'am.
only 3 weeks as an. Okay, we are directing to list both the matters too.
Well,
Therefore, I have made the part heard matter at 2.
Well.
I thought
Just a
I
quick,
have noted out.
just my lord, just quick refresh without opening the file. Your lordship recollect the last where I have stopped.
Yes.
The first, my lord, in a very quick to 5 minutes. First was that I have shown the dispute between the family in respect of a proceeding under 145. Just recollect that is of 2016. And an order was passed in respect of the dispute of 3 cutters, 10 lessers, where a status quo was granted by the learned magistrate. That's the first. Second, I took your lordship to the probate because your lordship just recollect that Subhadra Medi didn't have any legal heirs. So by a will, it was given to us, to the Birubhadra Medi. Birubhadra Medi has a wife and 2 sons, consisting of 3 cutters, 10 acres of land. So 2016, a probate case was filed. And there, your lordship just recollect, an application injunction was filed. Because one of my auntie, there's Bandala Medi, the family members, she was in possession. So I filed a suit for granting of an injunction that not to change the nature and character of this or nature and character of the suit premises. But the injunction was refused. That's number 2, my lord. Number 3, my lord, by that time we came to know in 2008, there was a sale deed was executed by Subhadra Medi in favor of Pradeep Kumar Das. 3 cutters, 10 lesser, which is in dispute, the property in dispute. Now that sale deed was of 2008. In paragraph 4, it is being stated that the physical possession was handed over to him. After a gap of 14 years, a mutation case was filed before the circle officer, and accordingly we appeared and we filed an objection before that, and we said about the profit and all those things, but the officer, the circle officer didn't consider. Accordingly, it was rejected. So thereafter, immediately with less than 14 days, the said property was transferred and sold it to one Sarita Devi Jain in the year 2017, which my learned friend is appearing on behalf of Sarita Devi Jain. So in 2022, it was sold. Now, there was also, they tried for mutation. Mutation, we appeared and we filed objection. Nothing would happen and it was rejected. So having no alternative, we filed a suit. Your lordship, I have shown the suit. What was the suit filed? The suit was filed following pressure declaration that all the mutations should go. Sale deed was in favor of Pradeep Das as well as Sarita Devi Jain, also to be declared as void and illegal, and it is all by way of forged mean, because there was no sale permission was taken, it should be set aside. So, and also prayer for a permanent injunction. So that is what we made. In pursuance to that, your lordship, a notice was issued. They appeared, and Pradeep Das filed a written statement. Sarita Devi appeared, and they filed a written statement. This counterclaim was filed, and your lordship will kindly see what was the prayer. That was the last where I stopped at page 135. The lordship will kindly remember that was 135.
Noted down there, 133 was last,
Yes.
135 now.
135, 134 is a confirmation of possession. 135 is a permanent injunction. At page 135. Lordship got it? 130. Challenging that my will also, that will which was a mere forged and fabricated in page 133. And 134 is, and 5 is confirmation of our position. And 135 is of a permanent injunction. This is a prayer which has been made. Against that, we file objection at page 139. Page 139 is a joint written statement filed by the plaintiff against the counterclaim. Lordship got it?
Yes.
If your lordship looks into paragraph 8, One 141.
Yes.
Relevant is 142. 142.
Yes.
142. Now they said in the counterclaim, they said that it has been I purchased, Sarita we purchased from Pradeep Das, where physical possession was handed over. By virtue of that, it was purchased by Sarita Devi. Mutation also, records of right also, it appears in her name. So that what it had been stated at page 142 kindly be seen. Second paragraph, first, second, third, fourth, fifth, sixth, seventh, eighth. Moreover, kindly say moreover.
Yes.
Moreover, the plaintiff had reliably learned that in the official page of Panjiyan maintained by the senior sub-registrar Kamrup Metro in property registration search page under computer generated number 22194 2008, the purported sale deed number 15840 dated 31/12/2008. That's in the name of Pradeep Das. Number, details and challan pertaining to the sale of scheduled land could be found. No details and challan pertaining to sale could be found. Now, it is relevant to mention herein that a plaintiff has also filed an FIR in Bharolimukh Police Station, Guwahati against defendant number 1, his associates and other government officials which were registered at numbers as Bhorlemukh PS case number 357 of 2023 under section 420, 406, 409, 468, so and so. And the said case was investigated by Crime Branch, Police Station, Panbazar, Guwahati. In the forwarding of the report for arrest of the son of defendant number 2, submitted by investigating officer Crime Branch before the Honorable Judicial Magistrate First Class, it is specifically mentioned son of defendant number 2 was manifestly actively involved with earlier arrested accused person Topaz Chaudhary in land grabbing of the scheduled land belonging to plaintiff. Because your lordship, at one point in time, we have done also a number of cases where a lot of land were grabbed by a lot of people, some brokers. So there was some anticipatory bail also was moved, some was arrested, and some interim protection was also granted by the court at one point of time. Maybe it's far back as 2 to 3 years back. There was a mass, I think all it was CM vigilance and all was picked up. Now, one this Topachok Chaudhary in the land grabbing of belong to plaintiff. Further, the said report also revealed the son of defendant number 2 as a close association with the arrested accused person in Bhorlemukh case, aware about the fraudulent activity of defendant number 1 and his associate. Moreover, the son of defendant number 2 has access to the force deed, sale deed number so and so dated 31/12/2008 and other related document which as per investigating officer was sufficient evidence to establish involvement of son of defendant number 2 in conspiracy to commit fraud and land grabbing activities of plaintiff external land. Upon perusal of document G of counterclaim, the order passed by circle officer dated 2010-2020 granting mutation in favor of defendant number 1, it is evident defendant number 2 was very much aware about the 2 number of court proceedings that are pending with regard to scheduled property of land, probate miss case number 12 of 2016 before the additional district and session judge and title suit number 130 before the civil judge number 2, Kamrup at Guwahati. As to the statement, environment of defendant number 2 is totally false, misleading, frivolous, and connected story of defendant number 2 in order to evade the liability against the plaintiff and mislead the honor. I am putting a pause for a moment. Your lordship knows that there is a form 50 where you have to declare before the authority concerned that there is no lease, nothing is against them. But there is a lease pendant, a case is there. 2016, you also recollect, and that's a probate matter. And this execution of the sale deed in favor of Sarita Devi Jain was in 2020. So it is a case where lease pendant. Yes, I will show it. So they could not have gone ahead with the sale deed of the second sale deed. Maybe Pradip Das, but not subsequently Pradip Das could have been transferred. Because my probate, which was filed, is in 2016. Probate was before the learned district judge was in 2016. And this transfer was 2022. And in Form 50, you have to mention specifically there is no case which is pending. In respect of the same property in concern. Same property in concern. Because when you put that, you have to put the same property in concern. Now, my lord will kindly, this is, now your lordship will please turn to paragraph 147, page 147, paragraph 11. 146, paragraph 11. Please turn to 147, subparagraph. It is submitted at 147. It is submitted that the plaintiff will already submit an application for cancellation of planning permit issued by reference number dated 27/6/2023 and no objection certificate for construction issued by reference number dated 29/9/2023 in favor of defendant number 2 before the Chief Executive Officer GMDA and the Commissioner Guwahati Municipal Corporation. It is relevant to mention here defendant number 1 in collusion with the Guwahati Revenue Authorities muted his name on 2010-2022 on the basis of 4 sale deed bearing number dated 31/12/2008 and thereafter inserted his name in electricity document that is APDCL. GMC holding number mentioned order of mutation dated 2010-2020 to 22 and a purported sale deed number 254043 dated 17/11/2020 pertains to the other property belonging to defendant number 1, which is situated at PNGB Road, Santipur Hillside, ward number so and so, and the suite land is situated Horlimuk, ward number 8. Moreover, defendant number 1, the circle officer, Latmandal, son of defendant number 2, official sub-register, have been arrested by the crime branch Guwahati in connection with Horlimuk police station, case number so and so, since they have conspired against the plaintiff by forging the title document with the intention to grab the scheduled land by clouding the right title interest of the plaintiff. And as such, the claim of adverse possession or counterclaim is completely baseless and does not have any leg to stand. So the APDCL, the house number, holding number pertains to Pradeep Das in respect of his property where residing. He have shown that. So there were a lot of hue and cry in there. And lot of people of registry, of register, sub-register was arrested. I'll show it, how it was done. So this is basically stand which we have taken, written statement, joint written statement against their counterclaim. Now, 156, 156, Annexure 9, 156, we file an application for injunction. Lordship got it?
Yes.
This is an application of injunction entitled suit number 505 of 2023. Against that, they filed an objection. I'll try to make it as fast as possible to short. 177 to 183 is the objection filed by Sarita Devi Jain. Page 177 to 183. My injunction is from 156 to 176, and their written objection filed by Sarita Devi Jain in against the injunction is 177 to 183. And the affidavit was sworn by his son, Sangeet Jain, at page 182. Now, if you're 183, 183 is the affidavit. Who was arrested in this case? The power of attorney was given to Sangeet Jain, who was arrested. Now, this is where I like to place how it was investigated, in what manner it was investigated. About these two, the property in question in respect of sale deed, initially made in Pradeep Das, thereafter transferred to the Sarita Devi Jain, who were also involved in this case. Kindly see. Now, the injunction which has been filed is still pending before the court. Now, kindly see at page 188. Is the FIR which has been filed by Dushmanthar Medhi, son of late Birubhadra Medhi. At page 188, and the FIR is dated. Now, my lord will kindly see 6/12/2023, I think. 6/12. Now, if you see at page 188 is the contents of the FIR, kindly see 188. Lots of got it? 188. See the second paragraph. Now, coming to the main story, sir, I would like to bring your kind attention to the fact that late Subhadra Medhi, son of Twins, never got married in his lifetime, and he was fond for his nephew, my father, a lot. And during his lifetime, by the register will number 10, having serial number 1232, was executed before senior sub-register Kamrup has been executed in the name of my father, late Birubhadra Medhi, son of so and so. And in that regard, the probate title suit number so and so is still pending before the Honorable District and Session Judge number 2, Kamrup. During the pendency of the case, once the Pradeep Kumar Das, resident of so and so, Santipur Hillside, Horlimuk, had made a 4 sale deed number so and so with 4 signature of of late Subhadra Medi so and so and applied for mutation in 2022 after a gap of 14 years. 189, my lord will kindly see first, second, third, fourth. Now to bring into your notice, lord, you got it? Late Lot Mandal, Ratneswar Das work jurisdiction doesn't pertain to Santipur locality, and PNGB road falls in Santipur area, which is under the jurisdiction of some other Lot Mandal. Under such condition, it is evident that the said Lot Mandal Ratneswar Das, in connivance with the land grabber, has submitted a false Lot Mandal report, LM report, misusing the power he had been begotten with, circle officer with malified intention, giving no eye to localities in his circle, has passed the mutation order based on such frivolous document. I have also annexed the GMC tax area notice pertaining to property in question to bring into the notice of a concerned office. Said Pradeep Das had never paid any GMC tax as clarified by him in the mutation application since 2008. So the Lot Mandal who was entrusted, he doesn't belong to that area. He belonged to Santipur area. So this was revealed at the time when he was arrested. And all this came out that he doesn't belong to a particular area. It doesn't fall in his jurisdiction. And a report was given. On the basis of that report, the circle officer went ahead. And our objection was also not considered, Your Lordship, 2022. That was not considered. Now, saying it is pertinent to mention here, I personally visit the office of the senior sub-register Kamrup and had gone through the pain of standing in the office for long hours just to check the online portal for property registration search page, name Panjian, and Mr. Nikul Sharma, who had been arrested, tried to dissuade me for a day or two by sending me here and there. And to my utter shock, I found a detail of 4 sale deed number 15840 dated so and so in the website portal. But when I checked on the tab to look into a detail of such deed, no challan revenue payment details could be seen as compared to the other deeds I had clicked on. And the front use of the 4 sale deed insert was also not matching with the front of the record of other sale deed fed in the portal. This proved the illegal official management at the senior sub-register officer Guwahati. And as per the recent report, it has come into notice of authority. Most of such forced deed has been executed on the last day of the year. This is what has been done. Well, you can now is on portal. So if you check and we found that something was inserted, which could not have been done. So at page 190, this was the FIR. On the basis of the FIR, the investigation was started. And slowly by slowly, one after another, the official, as well as some of the petition, the respondent, Sarita Devi's son, was also picked up. My lord will kindly see at page 193. After lodging of the FIR, investigation started. Right? See at page 193, the forwarding report. One Lot Mandal was arrested. Ratneswar Das, Your Lordship, I have just made Lot Mandal, who doesn't belong to the area, Santipur. He did not have an authority. He went and a report was furnished. He was arrested. Kindly see at 193. He was produced before the court, and at paragraph 194, kindly see, my lord. First, second, third paragraph, 194. Now to bring into your notice, forwarding report. What you got it? Now to bring into your notice, Lot Mandal Ratneswar Das work jurisdiction doesn't pertain to Santipur locality, and PNGB road falls in Santipur area, which is under the jurisdiction of some other Lot Mandal. Under such condition, it is evident that said Lot Mandal Ratneswar Das, in connivance with the land grabber, has submitted a false LM report, missing the power he had been begotten with. The circle officer, with malified intention, giving no eye to the localities in his circle, has passed the mutation order based on such frivolous document. Complainant has also annexed the GMC tax area notice pertaining to a property in question to bring into a notice of your concerned office, and the said Pradeep Das had never paid any GMTS claim by him in the mutation so and so. Now, if you see this next paragraph immediately, it is pertinent mention complainant personally visit the office of so and so, has gone to the pain of standing so and so, search name Panjian, so and so, so and so. Now, see 195 with the ground of arrest. Ground of arrest 1, the arrested person is so and so. Now, 2, during the course of investigation, the original case record of mutation order number dated so and so was seized by so and so. In the instant file of mutation order 1 GMC holding number so and so in the name of Pradeep Das was found, but in the instant order of circle officer GMC holding number 11049029 was mentioned. In fact, the arrestee has manipulated the original holding number 12172-831, but as circle officer, as per circle officer, it was mentioned holding number so and so. Thereby, the arrestee has willfully and intentionally inserted the holding number in the file to favor the land mafia Sri Pradeep Kumar Das and mislead the circle officer. Now, number 3, after perusing the report of Latmanda arrestee of the case, it implies report is prepared to support the illegal mutation order in favor of land mafia Pradeep Kumar Das. So this is what has been done now. This was the person who arrested. Please turn to page 197. Now, the power of attorney holder of Sarita J.V. Jain, son, was also arrested in connection with the present case. And at page 197, he was produced before the learned CGM. (197) he was produced before the magistrate, and at page 199, please see the ground of arrest at paragraph 5. 199. Sufficient evidence collected which establish Sangeet Jain's involvement in the conspiracy to commit fraud or land grabbing, as he is well aware of the forged document used for wrongful gain, collaborated with co-accused and have actively participated in the scheme. 6. Sangeet Jain had access to the forged sale deed and other related documents, which established he had possession and knowledge of the fraudulent paperwork. 7. Considering finding of investigation, Sangeet Jain's role in the creation, manipulation, submission of false documents, forged sale deed provides a strong legal ground for arrest. The role of Sangeet Jain indicates his attempt to obstruct the course of justice, independent witness, destroying evidence, influencing official, which stands to be vital ground of arrest. Accordingly, my lord, he was arrested, and this is a ground of arrest. Now, page 204, which somebody, one Topper Chaudhary was arrested, who was deeply connected with Pradeep Das. Now, 204, he was working in sub-registry office. One Jury Devi Sharma at page 204. 204, kindly see, man. Please see paragraph 2. In the course of investigation, the available concerned records of the sub-registry office were checked and verified with due approval of the authority, and during verification, it has come to light that the below named accused person was involved in the entire process of uploading the manufactured deed on dated 16/8/2017, whereas the sale deed is of the year 2008. It may be mentioned here that during the relevant period of 2017, below named accused was looking after a server of the sub-registrar office. Now that paragraph your lordship will skip next paragraph. Since the below named accused are earlier arrested in similar nature and bailed out, but he is required to be interrogated in the instant case to ascertain the name of the other accused person involved in this case. So this is what was arrested. Now, please see 209. 209. Now, this is an employee of sub-registrar office. No, Nitul Das.
Yes.
He is a junior assistant. Now, kindly see 209. Last paragraph. It is partner mentioned a complainer perceived with the office of so and gone through the pain of standing in so online portal, and Mr. So who had been arrested tried to descend for day or two. After and to utter shock, complaint found a detail of 4 sale deed number so dated so in the website portal, but when checked in the tab to look at the detail of such deed, no challan revenue payment detail could be seen as compared to other deeds. So front use of the sale insert was also not matching with the front of so sale deed fed in the portal. This proved the illegal official management of so as per the recent report. It has come to notice so such post deed executed on last day of a year and so. Now, ground of arrest, kindly see 2. Below mention accused required for custody interview to know why he has prepared a report without any verification under whom influence. 3. Knows the detail of their other accomplished government official of sub-register office and to take necessary legal action against them also in connection with the case. 4. Know and also to ascertain the entire money trail of transaction associated with this illegal manipulation of government deeds and manipulate the whole process of mutation in connection with the case. So he was also arrested in this connection. This circle officer ACS was also arrested. That is, you will find at 211 with a circle officer. He is the ACS officer. He was also arrested in connection with this case. 211. He is, Lakhajit Duaria. He was also arrested in connection with this case. So the mutation order was passed by him only. Both the mutation. Now, 217. Kindly see 217. Deputy Registrar, my lord, dated 12/12/2023, furnishing report against case number Bharlemukh case. What you got it? With reference to subjects and case number cited, I would like to inform you deed number 15840 is not available in fee book. But the deed in question is available in digital backlog entry in modified manner dated 16/8/2070 at 9:40 a.m. So somewhere in 9:40, before it was open, it was Jury Devi who was arrested in connection with also. It was managed. So how it came, my lord, digital backlog entry. And they did not find, because a fee book, it is available. They did not find it. In this connection, 2 officials, namely Debashish Barua and Nitul Chandra Das, junior assistant, who were assigned for old it rescanning, have been arrested. And there were both suspected to be doing the misdeed. So the deed in question is seemed to be fake. Now, this is important. 2018. This is Deputy Commissioner 218, my lord. Deputy Commissioner of Police Crime. My written to the DC. I just read this, my lord. This is dated 23/2/2024. 23/2/2024. See that investigation reveal forgery of deed number 15840. That is Pradeep Jain, Pradeep Talukdar, Pradeep Das sale deed. The fee book dated 31/12/2008. A critical document in this case was seized and a meticulous examination revealed a crucial omission. There is no mention of deed number 15840 on 31/12/2008 in the fee book. The Deputy Registrar, upon scrutiny, opined that the instant deed appears to be fraudulent. Notably, the deed in question was uploaded on 16/8/2017, further casting doubt on its legitimacy. Now, your lordship, 16/8/2017 is that upload 9:40 a.m. my lord, which I have shown how it is uploaded. Now, contradiction in mutation record. Mutation record obtained from Office of Circle Officer, Guwahati Revenue Circle, indicate a stark contradiction in the handling of the case, despite clear observation
in the order that probate miss case number 12 of 2016 and title suit number 130 2018 were pending in the Court of Civil and Assistant Judge number 2 and 3 Guwahati. A plot of land was unlawfully mutated in the name of Pradeep Das. This mutation was based on manufactured document as indicated by C's record. Discrepancy statement and contradictory relation. Further investigation has unearthed deceptive statements made during the mutation process. The then circle officer, after holding a hearing on objection raised by the informant, a letter dated 7/4/2020 made an observation order sheet. It was noted, অন্যহাতে আবেদনকারীয়ে উল্লেখ করা অনুহারী অপুস্তকারী এডুকেট দুষ্মন্ত মেধিৰ নথিভুক্ত কৰ্তাদিৰ সুভদ্ৰা বিধিৰ লগত কোনো সম্পৰ্ক নাই. Contrary to this, it has been established there is indeed a family relationship between Dushmanta Medi and the record Pattadas Subhadra Medi. During the investigation, it was discovered that the father late Virubhadra Medi of Dushmanta Medi was a nephew of late Subhadra Medi, placing them with the family lineage of late Kaliram Medi. Now, I have given the lineage there. Role of circle officer. It has been established that the deed and circle officer Sri Lakhajit Dwara possessed comprehensive knowledge of the family lineage and pertinent details related to property in question. Despite being aware of the established legal procedure and rule, the property was muted in the name of Pradeep Kumar Das, deviating from the prescribed protocol. Discrepancy holding number. According to a report from Guwahati Municipal Corporation, a plot of land in question which underwent mutation based on a purportedly forced sale deed is registered under holding number so and so. However, the mutation order indicates a different holding number, namely so and so, raising concern over the accuracy and legitimacy of the mutation process. Verification report now from Senior Sub-Registrar Kamrup. In response to the concern raised, the concerned circle officer sought a verification report from the office of Senior Sub-Registrar Kamrup, represented by so and so. The report dated 28 September acknowledged the registration of both the sale deed number so and so and will number so and so under the relevant provision of Indian Registration Act. However, the veracity of this report is questionable, as it suggests that the individual executing the will is the same person who acted as a seller in 2008 sale deed. This raises a fundamental legal question regarding execution of will in 2015, when the property has purportedly been sold in 2008. Documents which have been found to be false, fake, as per Annexure, it has been established during investigation that unscrupulous elements in coalition with government officials manipulate the original records, land record, to illegally acquire landed property by hatching a criminal conspiracy depriving the genuine landowners. In view of the above, we have requested review all such registration of deed which are found to be force fake and also subsequent mutation process carried on based on such force fake deeds in our document mentioned in XRA enclosed here. We are requested review all subsequent sale purchase carried out following the force fake sale deed documents, all subsequent mutation process. After review, appropriate action may be taken from the year, and as per procedure, action taken may be intimated to the undersigned, making it as a part of case record. So this was submitted. 220 is the sale deed. 220 what annexure is a sale deed of Pradeep Das. Now, if you see at 221, 221, DC, in pursuance to all the investigation that was made, has cancelled the mutation. Page 221. Seen and peruse the letter dated 23/3/2000 received from Deputy Commissioner of Police Crime Guwahati regarding fake forced land document prepared by forgery and manipulation, original records, and also by impersonation, which were used subsequently for mutation of land by unscrupulous element in their name, depriving the genuine owners and requesting for review of such record in mutation, where it can be observed from the investigation report of the Bharanamukh Police Station case number so and so, dated so and so, done were fake. Therefore, I, so and so District Commissioner Kamrup, do you have a district, direct the circle of Guwahati to cancel the mutation case number so and so immediately on report compliant. So on pursuant to date, the mutation was cancelled. Now, this was moved by Sarita Devi Jain against cancellation before the Honorable High Court at page 222. If you see at 225, my lord, kindly see at paragraph 11. Paragraph 11. On the effort, 225. On the efforts that count the impugn order dated so and so does not stand, law as is recorded set aside and quest, it is made clear that the impugn order dated and set and quest only for non-adherence to the principle of natural justice. It is further clear that any consequential action taken, impugn order will have the same bearing. Thus, the consequential action taken in respect to records of rights shall have same bearing. It is further observed that even respondent would decide to proceed afresh on matter, then respondent shall follow the principle of natural justice by putting the petition on prior notice and providing an effective and reasonable opportunity of being heard to be present before the respondent. Number 2, objection so and so is allowed to the indicator. So that was an ex parte decision which was taken. Court said you could not have taken that. If there is a mutation, there may be some manipulation also. At least a notice should have been given. So on this ground, a principle of natural justice was not followed. On this ground, the order was set aside. He didn't want to comment. He said proper notice should be given. Hearing should have been done. Not this way, by cancelling the mutation. Now, thereafter, notice was sent for fresh hearing at 227. Notice for fresh hearing at 19/7, 2025.
Pending.
Now, this is pending. I have been told this has been pending. In the meantime, now, before this 229, the permit, planning permit, everything was cancelled. Planning permit was cancelled. At 229, the order was issued at 230. 230. So building permission, whatever was there, that was cancelled. I'll not trouble that more. Now, please look into page 231. Here is the case where, please note this. This is important, which I'll tell why it is important and how the learned trial court has gone beyond the pleading in the injunction application. My lord, once the mutation was cancelled, they went off because they all also the police looking after, so they went off. Now, 231, where they sought for amendment of the plaint of their counterclaim. Amendment of the counterclaim. Please note the date. It is 4/6/2024 by Sarita Devi Jain. Now, they said that there is a forceful and illegal disposition. What they said that we entered. Once the mutation was cancelled, everything was not there. So we entered into the position of their position, they said. And they said they came up because now, my lord, you cannot just enter into it because the suit is pending, counterclaim you have filed. There you sought for confirmation of position only. Now, once it has been dispossessed, they filed an application before the learned trial court for amendment of the counterclaim under Order 6/2017. And what was that? Kindly see the first, in the matter of, at page 231, in the matter of forcible illegal disposition of defendant number 2, counterclaimant from the counterclaim plot of land by plaintiff after filing of WS dated on the strength of false and fictitious FIR dated 16/12/2023 filed by one plaintiff number 3 before so and so. The fact remains that your lordship will please note it. On 4/6/2024, they were never in possession. So what they tried rightly to file an application for amendment. And what was the prayer they made? Please look into the prayer which they have made. 236, kindly see. 236, paragraph 8. Paragraph 8. That after paragraph number 44D, petitioner defendant number 2 counterclaimant intended to insert the following paragraph as paragraph number 44D1. Right, my lord? Please look into 44D1. That during pendency of the suit and counterclaim, the plaintiff had forcefully and illegally disposed the petitioner defendant number 2 counterclaimant from her possession of counterclaimant scheduled property land and structures, and hence now the petitioner defendant number 2 counter praised before this court to pass a decree of recovery of possession of a counterclaim so and so by evicting man materials belonging to plaintiff therefrom, and also by removing, demolishing all illegal construction of the plaintiff over scheduled plot of land and structure, and khas and vacant position of same is delivered to the petitioner so and so, so and so. Now that the 9, petitioner defer counterclaim intends to replace for the paragraph 44 each of the counterclaim as follows. Petitioner defendant number 2 counterclaim prays for a decree of recovery of possession or counterclaim so and so, so and so. Now if you see 5 at page 237, recovery of possession of counterclaim so and so by evicting man material belong to plaintiff therefrom by removing, demolishing all illegal construction and structure, and the khas and vacant position of same may be delivered petitioner so and so through the bailiff of the honorable court, if required, with the help of armed police personnel and mandal assistant at the cost of petitioner defendant counterclaim. So my lord will kindly note down 4/6/2024. That's their own statement and case. They were never in possession. That day they were removed, and they are now trying for recovery of possession. This is what? Recovery of possession by filing this order 6, rule 17 for amendment of the counterclaim. Now, see at page 242. After 1 year, more than 1 year, at page 242, see 242, my lord. Kindly see this application for amendment under 6 rule 17. They have withdrawn. Kindly see disposal date 17/7/2025. So it's almost 1 year. 1 year, 1 month. After 1 year, 1 month, they decided to withdraw this. So there is no leave of the court, just they withdraw it. Now thereafter, what they have filed, 243, what they find, wherever they find that easiest way, they will go on that way. See at 243. Now what? What is it? Yes. We file an amendment in 243, my lord. And amendment we sought for confirmation of possession, that was not allowed, rest was allowed. Right? Now, there was an objection which was filed by them at page 259. And at page 286, my lord, they file an application for injunction, order 39, rule 1 and 2. Please note down the date, 17/7/2025. So what they have done, order 6, rule 17 file, 4/6/2024, almost 1 year, 1 month. After that, they decided to withdraw it because they sought for recovery of possession. Your lordship knows that there is some procedure. You cannot throw away some prayer has to be made in the main suit. Then only you can pray in the injunction application. Now see at 286. They file an application for injunction under Order 39, Rule 1 and 2. That was filed on 17/7/2025. Now, this is Order 39, Rule 1 and 2. They decided now this was withdrawn. This application for injunction, that is MIJK 666 of 2025, was withdrawn on 9/9/2025, which was filed on 17/7/2025. They have withdrawn on 9/9/2025 at page 286. At page 286, they have withdrawn. Now, after being withdrawn, they filed again an injunction application at page 321. Now, this is injunction application they have filed. Now, my lord, what they have prayed for, please look into their prayer. Now, this application was filed on the day when the injunction application under Order 39, Rule 1, 666 of 2025, that was filed. Because on 17/7/2025 they filed. On 9/9/2025 decided to withdraw it. And on the same date, they filed another application before the court, injunction application. Now, this injunction application, kindly see what is in the matter of, kindly see an application under Order 39, Rule 1 and 2, and so, file on behalf claiming seeking urgent temporary injunction, including temporary mandatory injunction under consequent direction, urgent interim injunction against the plaintiff. Now they are seeking for an injunction and also seeking a temporary mandatory injunction. So my argument will be, you did not make any prayer. Rightly, you filed an application under Order 6, Rule 17 for recovery of the possession on the ground that there has to be main prayer. Then you can sought for a temporary mandatory injunction. You cannot come to the court and say that no, you want a temporary mandatory injunction. So they trying to circumvent, to bypass all this, and they came before the court with an injunction application.
What about this earlier petition for amendment?
Amendment that they have withdrawn. They have withdrawn.
Subsequently, sorry, they have withdrawn.
They have withdrawn. They have withdrawn on 17/7/2025. Again, my lord, this is very important date. On 4/6/2024, they filed an application under Order 6, Rule 74 amendment. They sought for recovery of possession. They said that we have been dispossessed. Right, my lord? Now, they were sitting quiet. Nothing was done from their side. Waited for 1 year, 1 month, and they decided to withdraw it. On the day when they have withdrawn on 17/7/2025, on that day, they filed an application for injunction under Order 39, Rule 1 and 2.
Without being amendment of this,
No, that they have withdrawn it. No liberty has been taken, no leave has been taken. They have withdrawn it. Now it is, your lordship will kindly see that. Again, your lordship will look into it. 242, please look into it, my lord. 242. See 242, once again, my lord. See 242.
Yes. Allowed.
Withdrawn, so and so, according praise the Lord, the miscase disposed of on will dwell. So that application, which they have sought for amendment of the plan, because they know that when I seek for recovery of possession, there has to be made, like we seek my permanent injunction has to be, prayer has to be made, only a temporary injunction can be granted.
Yes.
So they decided to withdraw it. And thereafter, on 17/7/2025, which an injunction application was filed by them on the same date, 17/7, that also they have withdrawn. And on 9/9/2025, this application of injunction was filed. There they are seeking Order 39, Rule 1 and 2, and also praying for a temporary mandatory injunction. Now, if you read the entire statement in the injunction application they have filed, your lordship will find a lot of contradiction they are making. They are saying that we are trying to dispossess, they are trying to trespass. Some statement which starts from page 350, 321. Now, if your lordship looks into it, what they want at 323, kindly see. D. D at 323, their injunction application. An order of ad interim and temporary mandatory injunction directing the plaintiff, their representative agent, affiliates, servants, partner assigned in the interest, heirs, and any other person acting in concern with the plaintiff, directing them to remove all banners, movable, temporary fixtures, and other article left or placed upon or inside the suit property by the plaintiff, and or so and so. So, meaning thereby they were never in possession. The plaintiff banner, they said a lot of banners are there. Inside, they want a mandatory injunction to remove the banner. Well, I am asking myself, can you seek for a temporary mandatory injunction without making a prayer in the main case, which you have done it, but you decided to withdraw it? This is our case. And how the learned trial court has passed the order on the basis of this? That's our case, what we projected before this court. Kindly see at page 325. Factual and legal background, 325. The states Subhadra Medi executed so and so, admittedly so and came in possession of the suit property. So now they are seeking to the old, they are saying by virtue of the possession of Pradeep Kumar Das, where Subhadra Medi was executed, so we are in possession. Thereafter, by possession which was holding by Pradeep Das was transferred to Sarita Devi Jain. And by virtue of that, she was holding the possession. This is what they are trying to project. One end, it's a very lengthy, from 321 to it goes to 340, 360, 362, 360, 365. 347, 348, 348, 48. Now see that the gamut of the above facts proves plaintiff have illegally with intent, misuse and abuse process of law in a brazen attempt to A, forcibly and illegally try to dispossess the defendant number 2 from the admitted and rightful possession of the suit property. Number D, the trespass over the suit property, attempted to use it without having any established legal right over it. 40, in view of the above fact, defendant number 2 has earlier filed an application, so and so in the present suit, on account of malicious action of plaintiff in the respect suit property. Said injunction have been registered. Next date in the matter was fixed on 9/9/2025. Now, if you see, it is a contrary prayer which they have made. 348A, forcefully and illegally, right? You also got it. Try to dispossess, and D, trespass over the suit property and attempted to use it without having any established legal right or claim over it. So, what is your statement? How your statement is being made? One hand you are making a statement where you are saying that try to dispossess, and one hand you are making a prayer saying that you have trespassed over the suit property and attempt to use it without having an established legal right, which is correct. So if your lordship looks into it, it'll take a lot of time to read this. I will not read it. So all these are contradictory statement has been made in their application of injunction. a grant of ad interim temporary injunction, mandatory injunction. Now, prayer kindly see at page 360. 360 D. 360 D. An order of temporary mandatory injunction, what you got it? Directing the plaintiff, their representative agents, affiliates, servants, partners, assigned successor interest heirs, any person acting in concert with plaintiff, directing them to remove all banners, movable temporary fixtures, article left or placed upon an inside suit property or in connection by the plaintiff pending disposal of present suit and the counterclaim and so and so. And they have also prayed for appointment of Amin Commissioner to visit the site. And 362, again they are saying, pass an order restraining the plaintiff so and so, exiting, see, partner assigned so and so in concert with plaintiff, entering into, exiting from otherwise and otherwise interfering, disrupting and or disturbing the different number to appellant, peaceful possession of the properties collectively comprising so and so, so and so. These are all prayer, one prayer you are making something else, other prayer, there is a different prayer you are making it. So all these prayers are inconsistent. Now against that we find an objection. We see it from page 366 to 420. All this was taken to by us and ultimately it was heard and injunction order was passed on 6/11/2025 at page 421. Now see 434, paragraph 13. Paragraph 13. Paragraph 13. Now the moot question is whether the plaintiff could have taken over possession or interfered with the possession during pendency of the suit after admitting possession of defendant number 2 and praying for recovery of possession. So, with great respect to the learned trial court, this issue was framed by learned trial court. This issue, whether the plaintiff could have taken possession or interfered with possession during pendency of the suit after admitting possession of defendant number 2 and praying for recovery of possession. On record, there is no injunction order against any party. The Lordship will kindly say there was no injunction order against any party. There is no injunction order in favor of the plaintiff, even in probate proceeding. Thus, absence of injunction order means parties are free to change the admitted status of the landed property. Now, next. 14 is, my lord, we come with a clean hands. This is what they say. Learned plaintiff argued defendant earlier filed recovery of possession and injunction, later on withdraw both and file the instant application for injunction. Learned thus argued that defendant do not deserve any relief from this court. On the contrary, Learned defendant number 2 argued that it is a plaintiff who abused the process of law and took law into own hand and took possession, interfered, possession breaking the law in a most illegal manner. 15 is judgment of Dalpat Kumar was quoted. Now 442. Dalpat was 442. See at 442. Paragraph 21. So without going into merit of the respective claims over the property and what it appears that the suit property is in danger of being wasted, damaged and susceptible to change of hands. Now 442, my lord. The complex and peculiar factual metrics of the case necessitate the intervention of this court in the form of a temporary and mandatory injunction against the plaintiff at this stage. An order of denial of temporary injunction at any stage may cause irreparable loss and injury to petitioner defendant number 2 and will lead to multiplicity of proceeding. Further, the plaintiff cannot be allowed to remain in possession as it will amount to allowing a party to take benefit of his own. So, like admitting that we are in possession, the court is said, no, you cannot allow, we cannot allow you to stay, taking the advantage out of it. Now, the learned trial court has overlooked that there has to be a prayer for putting someone in. My lord, your lordship knows a mandatory injunction when it is under section 39 of the specific relief act, a mandatory injunction. Now, suppose there is injunction order which is passed by the court and saying that so and so are in possession, don't disturb the possession. Now, there is a violation which is made and I throw him out. No, there has to be, my lord, mandatory injunction, some obligation of the party, which has to be breached. Then the question of mandatory injunction will come. Otherwise, if there is no order, where is the question of a mandatory injunction to be granted? Am I clear, my lord? Order section 39 of this received relief act, when a mandatory injunction can be granted. I'll show one judgment of the Supreme Court. There has to be an obligation. Obligation, there has to be an order from the court. Where is the order of the court? You did not make any prayer. Now, what the court says, kindly see, my lord, the injunction. There was no injunction. There was no injunction. And they said that, yes, it's right. In probate also, there is no injunction. So, what it says, further, the plaintiff cannot be allowed to remain in possession. So, maybe what it means that we are in possession, you are not allowed to remain in possession, as it will amount to allowing a party to take benefit of his own wrong. In fact, in Mijje case number 824, the plaintiff, while admitting possession of different number to have prayed temporary injunction, restraining the different number from anything the suit land and proceeding with any construction over the same till disposal of the suit. The said petition is pending. If the plaintiff were really worried about the protection of the suit property and ought to have moved an appropriate application before the court for the same, instead of taking to possession directly without leave of the court, and their action cannot be allowed to be perpetuated. Now, he said that you entered into the possession, that illegal activities we cannot allow it. Now, your lordship knows. Now, suppose, my lord, for example, I'll just put what is 22, what it says. This is important. Kindly see 22. Considering above facts and circumstances, the court hereby direct the plaintiff to keep the hands of the suit property and not to interfere in possession of different number 2 till disposal of the suit. So, it's a lay of the hands. Now, suppose for a moment, my lord, in one property somebody has entered into it illegally. Can you throw him out? You cannot. There is an order of the court. I violate this order of the court. A mandatory injunction can be passed to put back into possession because there is an order of the court. My lord, a trespasser, your lordship knows in a trial court, used to do also cases in a trial court. A tenant, a landlord, the landlord, tenant comes to court and says that he is trying to evict me. Now, he has no agreement with the landlord. He is an illegal trespasser which has entered into the suit premises of the landlord. Can a landlord evict just like that? It's a process. The court says that you cannot evict without due process of law. I entered into the possession. Let's say in this manner, I entered into possession. What is the alternative? You can do it. Yes, your alternative was Order 6 Rule 75 amendment for recovery of the possession and also praying for a mandatory injunction. Even then, it cannot be passed because there is no violation. Mandatory injunction, there has to be some order of the court where it can be restored back again to the position. So here, the learned trial court is saying that no, you cannot be in possession. You have to put your hands, lay off from the property of the defendant. So I am asking, can this order, with great respect to the learned trial court, where he is making out a case where there is no question of they have not prayed for also. There is no main prayer. How can that be allowed? There has to be some prayer. There has to be some violation. So this order itself is bad. That is the reason why I have put to challenge before this High Court. That was the ground of arguing. Now, if your lordship looks into, I am again repeating, further the plaintiff cannot be allowed to remain in possession, as it will amount to allowing a party to take benefit of his own wrong. Now the learned trial court with respect, considering the facts and circumstances, the court hereby directs the plaintiff to keep their hands off the suit property and not to interfere in possession of defendant number 2 till disposal of the suit. Now, you are not in possession from 4/4/2024 when your mutation was cancelled. Let's say very boldly that I entered into the position. 1. But you know that this party has entered the position, knowing fully you file an application for amendment, for recovery of the position back. Correct, my recovery of position back. 1 year you waited. See the date. 1 year, 4/6/2024. You waited till 17/7/2025. 1 year, 1 month. Then you decide to withdraw it. Now you file an application injunction on 17/7/2025. That also you decide to withdraw it. Why? My lord, thereafter on 9/9/2025, you file an injunction. There you prayed for a temporary mandatory injunction. So my question and answer is 1, can this be allowed where you not made a prayer of it? Number 2, admitted position that you were never in position. So if there is no order of the court, can you again restore back the position? Status quo ante. There is no question of a status quo until and unless there is some order passed by the court. Order is passed by the court. Yes, this person has to remain in this position. Don't disturb it. I tried, I disturbed him and I throw him out. Then, my lord, of course, that position again can be restored back. This is what we do. Disposition, section 39, mandatory injunction can be given back. This is what my argument is, my. This order itself is a flaw in the order. This order could not have been passed. What the order could have been passed, with great respect, that's my humble submission, that the party's status quo as on today shall be maintained, whoever is in position. When I moved this matter, my lord, the argument was advanced. My learned friend, parties were also present. After hearing it, the court says status quo as on today shall be maintained. So that's the case, my lord, about it. So my humble submission is that this order is, my lord, is arbitrary, is perverse. This order could not have been passed. You cannot restore a particular position back to them when they were not in position on the face of it. So this is my humble submission before this court. Now I'll just point out certain judgment. Facts is this, my lord, and I have argued. This is my main point. Yeah, what's that? Copy log bolna দিব লাগে actually মই গালি দিব this is the real way দিব লাগে নিদিয়ে না আজিকালি মই কিতাপ দিয়েতো সুপ্ৰিম কোৰ্ট is mandatory here also তানো নাই কপি আছে নেকি আছে দে এটা কপি মই it is mandatory no you read book নালাগে but when you say it is mandatory দে এটা কপি দে ইয়াত দে আৰু দিবি দেই I'll try to finish it off there. I'm seeing the watch again. আৰু বহুত টাইম লাগিব এইকাৰণে আজিয়ে ফিনিশ কৰি দিওঁ গোটেই কৰি দিয়া my lord, 2025, 74, 75 and 76.
74, 75, 76.
74. 94. Just this section requires defendant or the party concerned must be prevented from a breach of an obligation under the contract. It further requires certain special act which flows from such obligation must be specifically proved. The act must have reference to an enforceable obligation. The breach of obligation and performance and compulsion to perform certain acts in relation to some obligation must be specifically established before a mandatory injunction can be granted. The plaintiff in a suit instituted by him under section 39 of the Act is obliged to satisfy the court with appropriate pleading and causal evidence. Defendant is committing breach of a particular obligation which is binding on him, and there are certain acts which are capable of being enforced by the court in view of the terms of the policy of allotment of plot, so far as the case of hand is concerned. Now, 75. Mandatory injunction by its nature embodied under section 39 Act is discretionary. The grant of mandatory injunction is a matter of judicial discretion of the court, and it can be granted only in case which falls strictly with the four corners of the provision section 39 of the Act. The two elements which govern section 39 of the Act for grant of mandatory are the necessity to prevent breach of an obligation by the intervention of the court. Please note down, there is a breach, necessary to prevent the breach of an obligation intervention of the court. Number two, that such act should be of that nature capable of enforcement by the court. Yet another ingredient is also available, which is crucial in the matter of grant of mandatory injunction, that it should be amenable to exercise of judicial discretion. A relief which is not amenable for exercising judicial discretion of the court cannot be granted by way of mandatory injunction. It should satisfy not only breach of an obligation and necessity of its prevention, but also the availability of judicial discretion to be exercised. A mere breach of an obligation to necessity or necessity to prevent the same alone cannot be brought under the purview of mandatory injunction unless the same is amenable by exercising discretion by the court. These are the conditions, my lord, granting mandatory injunction. The condition for granting a mandatory injunction has developed over time by catena of decision by this court may be summarized under: first is obligation. There must be clear obligation on part of defendant. My lord, there has to be some obligation, clear obligation. Where is that obligation? There has to be some obligation. Number two, breach. A breach of that obligation must have occurred or be reasonably apprehended. When there is no application, there is no breach. Number three, necessity. It must be necessary to compel the performance of specific act to prevent or rectify the breach. Where is the order, my lord? There has to be some order where they were in possession, some order of the court, thrown away. Again, they came up and said that restore the position back. So there was some obligation. I know that. Here, where the court themselves said there is no injunction of the parties. Probate also, there is no injunction. So, enforceability. The court must be able to enforce the performance of those acts. Balance of convenience. The balance of convenience must be in favor of the party seeking injunction. Irreparable injury or damage caused by breach must be irreparable or not adequately compensated in terms of money. So this is the ingredients when a mandatory injunction has to be granted by the court. Now this is one. Then number two. The other side of the people like that. Otherwise, they will not. My lord, is paragraph 4. Here, my lord, relief which has not been sought for in the main case, whether that relief can be granted. It is true. That's the main. Now, please see. 445. First, second, third, fourth, fifth line. On the top, first, second, third, fourth, fifth line. A party cannot, 445. First, second, third, fourth, fifth line. A party cannot be granted a relief which is not plain. If the circumstances of the case are such, a granting of such relief would result in serious prejudice to the interest party and depriving of valuable right under statute. In an action or by a landlord of a tenant, is expert defend only the claim made against him, and if the cause of action arises to a landlord on the basis of plea set up by the tenant, in such action, it is necessary landlord seeks to enforce that cause of action, the same proceeding by a suit amendment or by said proceeding to entitle landlord to relief on the basis of such cause. Principle that the court is to mold a relief taking in consideration subsequent event is not applicable in such case. It is not a read case where you can mold, relief can be molded. It is a CPC where a pleading has to be made. Only thereafter relief can be granted. It is not a case under Article 226. Yes. Yet here, if the principle of the court is to mold the relief taken in subsequent event is not applicable in such cases. Now, my Lord will kindly see 222. Same relief not found in pleading. Para 15 and 16. Para 15 and 16. Pardon? Relief not found on pleading should not be granted. If the court considers or granted relief for which no prayer or pleading was made, depriving the option to oppose registry, it would lead to miscarriage of justice. So relief which has not been claimed for in the main. 15 and 16, your lordship will just note down. We will not waste much time this matter. Now, difference. Suzuki.
Yes. Para 12.
Para 12. There it says that you cannot take different stand at different times and also cannot contradict stand in the same case. Let's see paragraph 12, my lord. A litigant can take different stand at different time but cannot take contradictory stand in the same place. A party cannot be permitted to appropriate and reprobate on the same facts and take inconsistent shifting stand. Untenability of an inconsistent stand in the same case was considered in so and so. The court want to make it clear an action at law is not a game of chess. A litigant who comes to court invokes must come with a clean hand. He cannot prevaricate and take inconsistent position. In case also here, my lord, here also you cannot take a different stand. You cannot shift your stand. One hand you are saying that disposition may dispossess. 1 year you are saying that no trespassing. They are trying to trespass. You are taking all different stand. Shifting your stand. Returner's Consultancy Private 2001 3 SCC page 68. Paragraph 5, my lord. Yes. 5, paragraph 5. In these circumstances, no useful purpose will serve in keeping this proceeding in this court pending and orders made by High Court as modified by the court so effective until further orders are made either on the trial side or on LPA in respect of those reliefs sought for different application either pending or not effectively disposed of by allowing or rejecting or in any similar manner press or new appeal. Now, the High Court shall decide on such application bearing in mind the salutary principle that an interlocutory order is made by way of aid to the proper adjudication of the claims and dispute arising in and not made beyond the scope of the suit or against the parties who are not before it. Is not an against party, is beyond the scope of the suit. That neither excessive conservatism nor traditional technical approach nor overzealous activity approach is conducive to advancement of justice. So which you are not claiming in the main suit, can you come up with an aid of an injunction application? Now it is very. Now I am showing a judgment of least pendency case, my lord. When a will and probate is pending, that is paragraph 45, 46, and 47. Lordship will just recollect the dates. 2016, the probate, the transfer of Pradeep Das property to Sarita Devi was 2017. By then, prior to that, this list was pending with probate. And how it has been dealt, kindly see. Yeah, no? Yeah. Now see paragraph 45, no? 45, no? 45, no? 45. G is lease pendants. You also got it at page G, before 43. This one, no?
Before?
43 lease pendants. Lease G. At para 40, 41, 42, after 42. G, kindly see G. Lease pendants.
Yes.
Now please turn to 45. Section 52 of TPX states that during the pendency in any court or any suit in which any right or human property is directly and specifically question property cannot be transferred or dealt with by any proper party to a suit or proceeding. Explanation of the provision states that for the purpose of this section, the pendency of a suit or proceeding shall be deemed to commence from the date of presentation of the plaintiff or institution of proceeding in a court and shall continue until the suit or proceeding disposed of by final decree and order and complete satisfaction order is obtained, and it is become unobtainable by reason of the expiry period of intimation, section 52 of Transfer of Property Act. During the pendency of any court, so and so 52. Now 46. The following conditions ought to be fulfilled for a doctrine of pendants to apply. There must be a pending suit or proceeding. Number B, the suit or proceeding must be pending in a competent court. The suit or proceeding must not be collusive. A collusive is not a real suit, but a sham where the claim is that put forward. The right to involve property must be directly and specified in question in the suit or proceeding. That is the same property, my lord. 3 cutters 10 lecture. 47. In short, the doctrine of lease pendants that section 52 of transfer of property encapsulates bar the transfer of suit property during the pendency of litigation. Only exception of this principle is when it is transferred authority court or transfer on the terms imposed, where one of the parties to a suit transfer the suit property or part of it, third party later is bound by result of proceeding, even he did not have notice of the suit or proceeding. So here is a case where this was filed in 2017, 2016, and the transfer of the sale deed was 2017. So it could not have been transferred. This is our case. So this is one. Are we at that? Yes. Now I just last judgment. Now your lordship knows that minus C48. At 48.
Yes.
The doctrine of merger or the merger doctrine civil proceeding is a common law doctrine that stems from the idea of maintenance of decorum of the hierarchy of the courts and tribunal. The court is correctly sum up the meaning of doctrine as the doctrine is based on a simple reasoning. There cannot be at the same time more than one operative order governing the same subject matter. To put it simply, if there are two orders passed on the same subject matter, that is one passed by subordinate court, like a tribunal, and other passed by superior court, like the High Court, the operative part of the order by subordinate court may be merged with the order of the High Court. So there is an order passed by the learned trial court. Learned trial court, what it says, my lord, says that lay off your hands, and because we have to protect the possession. Now the matter heard, and the order of status quo as on today shall be maintained. So the order of trial court merged with the order of the High Court.
unless your lordship passes an order differently is something else. Okay, your order is hearing the entire FAO.
So I think.
Madam, what
think
I'm
that,
saying-
Another hearing is required for the FAO.
I'm here, your FAO is hearing.
No, we are hearing on FAO only.
Yes, yes.
Not hearing any.
No, what
like,
I'm
we are
saying-
hearing FAO.
The FAO. No, why I'm showing this, the trial court order merges with the order of this High Court. This is what I'm saying. The lordship is no doubt hearing the FAO main case. So I think that's my submission before this court, man. I'll not brag too much. I could have read each and every judgment, but unless it's taking time, my learned friend will address the court. My learned dear friend, Mr. Rintu. We call Rintu, he called me Jitu by nickname. We fight in the court, they're different altogether. Relation is
To address him.
relation is something else. Relation, he calls by
see.
my nickname, I call his nickname.
I also address you, Dada. I might address him
Yeah.
also as Dada. What to do?
Well, that's why I'm saying we are, what he'll say, so many ages we are friends. He will argue his case, my argue I'll case. Nothing is there personal. He doesn't have any personal. I don't have any personal. My learned friend doesn't have any personal. We should not keep. We should not keep.
Obviously.
It's a brief. We are holding it. Into four, bhai.
I don't think you can finish by
No,
today.
no, no.
Time.
Let us hear up to 4:15, then again we have to
Yes,
fix
yes,
another day.
yes, Lordship.
No issue.
I'll go slow, Lordship. I have to take some time in this matter, Lordship. My learned friend is very nicely in a capsule he has given it.
I'll just take your lordship leave and my learned friends will note down. I'll get a chance if
You use the right of reply, always. Use the right of reply.
my learned friend son is also here. We call
Yeah,
him
yeah, I know. him.
Baba, we call him. Deeply obliged, silently.
Lordship, may please come to page 73 because you're hearing the first
70
appeal. I'll
70.
go to the later on in the miss case. Let us go what is the suit about. Page 73.
Yes. 73 is the main, the plain
Yes,
of the
title should plain. It is the plain clause. Lordship, here Lordship will take note in the first page itself. The defendant number 1 is Pradip Kumar Das. And Lordship, in the first appeal, Lordship may please come to the first page of the first appeal in the cost title at page 2. Page 2 of the first appeal.
Yes.
It is started with Dotikona Medilosugeti.
Hmm.
They are the appellant. Now versus
Sarita.
Sarita. This Pradip Kumar Das is not before a lordship. Much has been said against him, the sale deed, all this fraud, everything. He is not a party. He is not a party. He has filed a written statement. He has filed a written statement which is not on record and he is not a party before this court. And much has been said against Pradip Das. Much has been read against Pradip Das. He is not here to defend himself. So this Pradip Das is not there in the first appeal. Now, Lordship, I am Sarita Devi Jain. I am here in this case. Lordship can see it is the Sarita Devi Jain is the respondent. Lordship. Now, Lordship, from the next page, page 74,
Lordship will see all these person from 3 to 10, all of them were made pro forma defendant. Lordship knows what is pro forma defendant in a suit. So they were not before this court, and all these things, Lordship, the will made by someone, there is a probate case pending. That probate case is pending. What is happening in that probate case? See, Bornali Medi appeared in the probate case. All these things, but those parties are not before this first appellate court. All of them are not here, not made party. Now, Lordship, what for the suit is, let us see at page 75. It is a suit for declaration, permanent injunction, and for other relief. The suit is valued at 1.60 crore, then court fee, highest court fee paid, everything. Now, here, Lordship, in the paragraph 1, now my learned friend has given he's a senior counsel, my lord, whatever he has been briefed, he will give to your Lordship. So whatever he was briefed, he has given to your Lordship. There is a genealogy, Lordship, the family tree he has given.
Yes.
This family tree, in my humble submission, is wrong. It is not correct. I have taken a certified copy, Lordship. And then I'll go one by one, Lordship. Why I have I am now paragraph 1. I am there in
So you have
paragraph
also
1.
collected the family tree.
Yes.
Acha.
I have given I have given a family tree. I'll give in my written argument and all. Yeah, I have given all everything. It is already there, Lordship. I'll hand it over. You have to copy. You have to copy. You have to copy. You need to. Lordship, I'll read it later on, Lordship, because they have to make a copy. Go and make a copy, then I'll. No, I'll not read. Bona and copy. You report over letter. Now here, Lordship, in the paragraph 1, at page 76.
Yes.
That one Kaliram Medi had 3 sons, Rambhadra Medi, Surendranath Medi, and Subhadra Medi. He is all deceased. And late Rambhadra Medi was the predecessor in interest of the plaintiff, as well as the pro forma defendant number 3 to 9, and the pro forma defendant number 10 is the legal heirs of Surendra Medi and late Bandhana Medi. The plaintiff are the legal heirs of Birabhadra Medi, son of Rambhadra Medi, who died on so and so. Now, in this case, Lordship, if Lordship will go by the plain, Lordship, the sum of the suit pending between these parties of the family member is not mentioned. There is some suit, that is what I want to show, and that on all those suit, written statement filed, stands taken. In the written statement, a stand is taken that the Subhadra Medi is the son of the third wife of Kaliram Medi. Where is that, all that, Lordship? It is a stand taken in the written statement, Lordship. All these things are not there in the plain. Lordship will not get. That is why I have taken the certified copy. I'll give a copy, then only I'll read, Lordship, otherwise I cannot. Because this is, if Lordship, without knowing the fact, Lordship will pass some.
Where from you are saying that there are other suits are also pending before the family, between the family members?
It is the trial court, it is there, Lordship, now. In our year also I have given, but it is not there. It is not annexed. We have pleaded also. It is not before this court, it was not annexed pleadings are there, Lordship may please come. What is the paragraph? Lordship, page 79, paragraph 7.
Yes.
Why I want to show Lordship in the earlier suit also. The present plaintiff has filed application for injunction. Those are rejected. The predecessor interest in plaintiff Bhai Ballabhadra Medhi during his lifetime as plaintiff has also instituted title suit number 130. Lordship get it, Lordship take note of this. On 26/3/2018 against Bandana Medhi, since this is, as well as to the Deputy Commissioner Kamrup Metro under praying for permanent injunction restraining Gator in so-and-so, no in respect of so-and-so, property owned by so-and-so, upon receipt of the aforesaid title suit, so-and Bandana Medhi has contested the claim and the plaintiff herein filing a written statement which is pending disposal before the court of civil judge number so-and-so. Now, this plain Lordship is not annexed. So, Lordship will not get the fact. And the written statement is also there. And in the written statement, those statement is there. That who is Subhadra Medhi? What is the right of this son of all this Ballabhadra Medhi and all this person? She has written everything. That by nature they are encroacher. They always try to interfere with the position of the others. She has written everything in the written statement. And it was also written that they have stolen money from the bank account of the family. Now they say family man is in possession. Now they say the family man is possession. That family man has said that they stolen money from the bank account. And Lordship will not believe that girl now contesting is mentally, she has some Lordship, and not well. Then a board was constituted by the trial court. Guardian was appointed. The board has given a certificate that yes, this girl has some problem. So guardian is appointed. That type of girl was in problem, Lordship, because of this plaintiff, all this plaintiff. And that appointment of the guardian is also challenged before this High Court. And High Court has given judgment. Now that is, yes, final order is pending, but that is pending before the High Court. That is also challenged by the plaintiff. The appointment given by the board. Then, Lordship, this is this title suit number 130 of 2018. Now, before that, Lordship may please come to para 4 first. Page 76. Because Lordship to know for this 3 kata 10 lesses of land, how many suit is pending, how many injunction was rejected. So that must Lordship know, because all these things are not here in this first appeal. Missing. The Dr. The demise of Subhadra Medhi, Sri Birabhadra Medhi, then alive, filed an application under the provisions of Section 276 of the Indian Succession Act for probate of the said will dated 17/1/2015 before the Honorable District and Sessions Judge Kamrup Metro in the year 2016. On being contested by the deceased mother of pro forma defendant number 10. Now, Lordship, this pro forma defendant number 10, that girl I have said, has contested this suit. Filing written statement. I will read this judgment also, Lordship. Said probate application, judgment too late for page, for him. pro forma defendant number 10, the said probate application was registered and numbered as probate title suit number 5 of 2018, which is presently pending disposal before the Honorable Court of the Additional District Judge and District and Session Judge number 2 at Guwahati. It is relevant to mention herein that during the pendency of the above mentioned probate title suit 5 of 2018, Sri Birabhadra Medi, since this is died, leaving behind his plaintiff herein as his legal heirs, by the order dated 6/9/21, passed in probate title suit number, the plaintiff herein was substituted in the place of their predecessors in interest by Birabhadra Medi. Further, the plaintiff submit that except Sri Bandana Medi, that is the mother of the pro forma defendant number 10, none of the opposite party pro forma defendant 9 has the contested the above mentioned probate title suit number 5 of 2018. The plaintiff crave of this honorable court to rely and refer, Lordship, it is their leave. So that is why I am showing. Made in the probate title suit number so and so at the time of the instant case. Now, Lordship, in the probate title suit, the injunction was rejected. 36. Lordship, may please come to page 36. Pausing here, Lordship, I'll come to page 77 again.
Page
Page 36. Because you have to go one by one, Lordship, otherwise Lordship will not get the thing.
Yes, statistics. 36.
This is the PTS number 5 of 16. There is a miscase 71 of 2007, Birabhadra Medi versus Sambhadra Medi. Lordship, get it. Parties are represented by their engaged counsel. This order is arising upon the both sides, learned advocate on the petition number so and so, filed by the petitioner under 39(1) and 2, read with section 151, praying for grant of temporary injunction, restraining the opposite party number 8 from constructing any permanent structure over the schedule mentioned in so and so till disposal of the so and so, and retain objection thereto in so and so. So now what is their prayer? That the opposite party number 10 will not construct, will not do anything. That is, so they were not in possession on that day. At least, Lordship, for the purpose of the possession, I am showing this, Lordship. What the court has given finding, I will read directly. Page 38, Lordship. 37 to 8 hobo. Huh? Okay, Lordship, may please come to page 37, last paragraph. Lordship, again read. From the averment of the petitioner, it is but clear that the answering opposite party has been in possession. It is the opposite party. Lordship, it's a clear finding, Lordship. Not the plaintiff. The plaintiff is the plaintiff in the probate suit also. So, from the averment the petition, but it's clear that the answering opposite party has been in possession of the scheduled land, as because only a person in possession of the land can carry out construction over the land. Lordship, get it? A person in possession of the land has a right to enjoy the property so long he is not dispossessed therefrom in due course of law. Lordship, were to take note of this. Why, Lordship? The PTS is pending. The due process of law, when you completed that, you have entered into the possession now of that plot of land, when the PTS is pending. Now, with the smiling face, you are saying, no, we have entered into the possession. Now, they're showing some technical here. Now, they have filed some counterclaim, they have withdrawn, they have filed a new miscase, all that. First come first. page 37. The first possession, who is in possession? From the averment of the petition, it is but clear that the answering opposite party has been in possession of the scheduled land, as because only a person in possession of the land can carry our construction over the land. A person in possession of the land has a right to enjoy the property so long he is not dispossessed therefrom in due course of law. Now in our case, Lordship will take note of one thing. This lady is not before this court challenging that my position is taken over by the respondent Sarita Devi because they sold out to Pradeep Kumar Das, 2008, and given in the sale deed itself, it was written, much has been read, Lordship. I'll show one by one. Now all these documents they have read, Lordship knows, filing a case in the Vorolmukh police station, arresting my son. Sarita Devi was not arrested. My son was arrested. And then you say, there is nobody to look after the land, so we entered into the possession. That is their stand. I'll show, Lordship. The petitioner, being not in the possession, cannot exercise his right to property till he came into the possession thereof. During the course of the argument, the learned advocate answering opposite party submitted that the petitioner has failed to make out a prima facie case, cause of action for the injunction, as he could not say with certainty that there is any overt act on the part of the petitioner which constitute a cause of action. Mere statement in para 3 of the petition that the petitioner came to know that the opposite party number 8 has been trying to sense the nature and feature of the property is a very vague statement. Questions come as to when did he come to know, from whom he came to know, how he came to know, what overt act on the part of the answering opposite party prompted the petitioner to know that the opposite party number 8 has been started construction are not explained, answered by the petitioner. Where the cause of action for the case could not prima facie establish, and it is found on record that the opposite party has been in possession of the scheduled land, no prima facie case is found in favor of the petitioner. So there is no prima facie case, arguable case in favor of the petitioner. That is on 31/11/18. 31/11/2018, this is the finding of the court. Secondly, the petitioner filed the petition claiming injunction pending disposal of the petition for grant of probate. Lordship, this is the main part, the whole part. Lordship will get the whole answer of this. What right petitioner filed this present suit now? Now the answer is this, Lordship. The present petitioner's right to file a suit is the answer is this, Lordship. The court has already, and Lordship will take note of one thing. Somewhere Lordship has to read, this attains finality, no appeal, nothing. This attains finality. I'll go to that. Suppress, fraud, all these things I'll argue. Why you are so hurry? Fraud is apparent, Lordship. And fraud I'll slowly, Lordship, because that day I lose my temper. Because it is, Lordship, sometimes Lordship happen. Lordship. The clients suffer, then all these things happen. So my learned friend saying me fraud and all that. I'll go slow, Lordship. Because I have to show one by one. See how frivolous, how fraudulent these persons are. I'll go one by one, Lordship. Only when the probate certificate, I'll read at the cost of repetition, Lordship. This is court order, Lordship, and attains finality. Secondly, the petitioner filed the petition claiming injunction pending disposal of the petition for grant of probate. Only when the probate certificate is issued in favor of the petitioner, then he would acquire an interest over the property involved in the probate proceeding. Lordship, this is a clear finding. Nobody has challenged this. So when his right in the property will come, when the probate will grant it. Today, there is no right. The court has given a finding, and this finding attains finality, no appeal, Lordship. So next line is, it is one step ahead, Lordship. Moreover, where the petitioner has no right, no title, interest, and possession over the scheduled land, there cannot be any loss, less to speak of irreparable loss if the injunction is refused. I again at this say that it is 30/11/2018, clear, court is clear on that. The opposite party being undisputedly in possession of the land in question, if restrained by grant of injunction, his right to property, a constitutional right, will be restricted, and any such restriction curtailment would entail the irreparable loss, as curtailment and restriction of any right cannot be compensated in terms of money. So, the balance of convenience is also in irreparable loss also found lie against the petition. All these three golden principles govern grant of refusal of grant injunction, lie against the petitioner. The prior for grant of temporary injunction is rejected. Miscase stand dismissed on contest, however, without cost, given under my hand and seal, so and so. So, Lordship, now I will come to page 73 again.
What
Now,
is the present status of that probate case?
Probate case, Lordship, the notice served, some of the parties appeared, even we have filed an application, Lordship, under Order 1, Rule 10-2, to made as a
Did you
party.
as a party?
Yes, and because Lordship, the Lordship knows that if somebody has some right and somebody else has entered into the possession, I am nobody to give them suggestion, Lordship, then the Order 21 is very clear how to file an application, Lordship. Order 21, there are provisions. If during the
It's a
pendency
big-
somebody has entered
The
into it.
big Ostra.
So, Lordship, I was reading at para 7, Lordship. Para 4, I have read, Lordship, this regarding this title suit 5 of probate title suit 5 of 2018, and then I read the order. Now, Lordship, Lordship has asked me the question that what is the position, paragraph 5, that the written statement is filed by Bandhana Medi, it is in paragraph 5. And in the written statement, Bandhana Medi has given everything, Lordship, everything. What is their right? It is shown in the written statement. Those things are not here, Lordship, not annexed. And everything. Now, Lordship, the paragraph 5, then paragraph 6, he has said that there is a registered will made by Subhadra Medhi, the Bandhana Medhi again. Lordship, this is something different. There is another, Lordship, revenue appeal and all that in paragraph 6. So I do want to read the paragraph 6. I'll read para 7, Lordship. Para 7, Lordship, the title suit 130 of 2018 is referred to, Lordship. Lordship, I have given the certified copy of title suit 130 of 2018, including the order. Yes. Lordship, get it. So, Lordship, may please come to the WS, written statement. They are in the backside, Lordship. After page 6, Lordship will get. Up to page 6, it is the plain, then the written statement, Lordship.
Yes.
Written statement on behalf of 3, 4, 5, and 6. And the Bandhana Medi is the defendant number 3. And Lordship, for that purpose, the Deputy Commissioner is a necessary party in the other suit. Lordship will take note in the title suit 130. This Veerabhadra Medi, same man, has filed the suit where the Deputy Commissioner is a necessary party, where the Sub-Registrar is a necessary party. Everyone is there. In our case, they have asked for precept, but the Deputy Commissioner and nobody is made party. There is a prayer for precept, I saw, Lordship, in the prayer. So now, Lordship, may please come to this written statement, because written statement, Lordship will get everything. The character of the person, the conduct of the person, Lordship. Lordship, may please come to page 2. They have given me the certified copy, so I cannot put the line also. That's my whole problem. So I'll read the page 2. In this regard, it is pertinent to mention herein, late Subhadra Medi was the full brother. Lordship will take note because the genealogy is given. My learned friend has no whatever has been briefed, he has given to the court. In this regard, it is pertinent to mention herein that late Subhadra Medi was the full brother of the answering defendant's husband, namely late Surendranath Medi. All other parties arranged in the instant application are successor in interest on half-blood brothers and sisters. Lordship then have to go to the... Lordship, it is true because 3 wives, Lordship. Now, Lordship will one by one, Lordship things will come out. Family tree, Lordship will come out here. The instant application of success in interest of the half-blood brothers and sisters of late Subhadra Medi, late Surendranath Medi, that is the husband of the defendant number 3, and late Subhadra Medi, were born out of the wedlock of late Kaliram Medi and his 3rd wife. Lordship, get it. At the cost of repetition, I am reading. The wedlock of late Kaliram Medi and his 3rd wife, late Swarnalata Medi. Said Kaliram Medi had 2 more wives, though whom various other children were born, including the predecessor interest of the plaintiff. All those are not parties. Not pleaded anything, Lordship. Everything is suppressed. When they know, because this written statement is there. And what they do, Lordship, after this written statement, I'll read the, that is why I have taken the order of the court also. I have certified copy, I have given. It would also be opposed to state herein that after the death of Kaliram Medi, the 2 sons born out of the 3rd wife were Surabhadra Medi and Surendra Medi, by way of amicable settlement, with the other heirs has separated their share of the ancestral property. Lordship, get in? Family possession, family property, all these things now in the present suit. Now this is the answer to all this. What you have referred to in paragraph 7 and the not annex the plain, this is the answer. And it is filed in June 2018, Lordship. I'll give the date, Lordship. 27th of June 2018 in the affidavit, the signature is there. And the copy received by the plaintiff. It would also be opposite state that the death of Kaliram Medi, so-and-so, Subhadra Medi, so-and-so, with the other heirs has separated their share of the ancestral property comprising of the land mentioned in Schedule A of the plain from the other half-blood brothers and sisters. The said land has been running in the name of the Subhadra Medi and the answering defendant in the revenue record. Because, Lordship, nowhere the name of the plaintiff is there. Lordship, suppose, for a moment, there is an agreement between A and B, sell deed. Who will challenge that sale deed? that this is fraudulent. If the A is affected, A's right is affected, A's legal heir is affected, they will come. 2008, if a sale deed is made, only because you are in power, Borolumuk police station is your pet dog. All the police officer are your pet dog. So you'll get all these things. Police officer can nowadays decide the title of the land. A DCP crime said, I look at the signature and the signature is not tallied. He has not sent it to the forensic, nothing. He has given a finding. So why this title, all this trial court is needed, Lordship, nowadays? All efficient police officer, all efficient pet dogs of the plaintiffs, they are there. They can give the finding. Pursuant to a relinquishment by Subhadra Medhi, and upon his death, the name of the defendant number 3 has been mutated in place of the deceased Subhadra Medhi. Hence, unless the plaintiff succeeds in establishing the genuineness of the will, so say again, it is very specific. The aforesaid probate proceeding, it is the defendant number 3 who will succeed the estate of late Subhadra Medhi by way of inheritance. Clear, Lordship. Probate is pending. I have already shown. This written statement said that my position and I am the successor. My name is there in the nowhere the plaintiff name is there, Lordship. Let them show one Jamabandi that their name is there in the Jamabandi. That they have title, they have to establish that before the trial court, before get an injunction, Lordship, or to get a status quo order and they, at night, Lordship, wearing helmet, enter into the someone's land. Some title, some right. Moreover, at the earliest time of execution of the will, Lordship will get it. Moreover, the earliest time of execution of the will, late Subhadra Medhi was suffering various ailments and health issue, partly attributable to his age over 80 years. During the said period, he used to talk irrelevant things and was not in a sound state of mind. The plaintiff who had been eyeing the property once took Subhadra Medhi with him on the pretext of medical treatment. He then admitted late Subhadra Medhi in a hospital at Guwahati. But later on, the plaintiff abandoned his uncle and late Subhadra Medhi was left unattended. The hospital authorities thereafter being left with no option, discharged late Subhadra Medhi from the hospital, and a month later Subhadra Medhi died. It is during the time of the plaintiff has manufactured the alleged will taking advantage of the late Subhadra Medhi's unsound physical and mental health. The plaintiff was also attempting to withdraw money left behind by Subhadra Medhi in his saving account number so-and-so in the overseas bank Panbajar by falsely posing as a nominee. In this regard, the defendant number 3 is not in custody of all the relevant documents and hence this she crave leave of the court to submit the same as and when the same are made available to her. Pausing for a moment, Lordship, in the title suit, now we will decide, who will decide? The trial court will decide. My will is, my sale deed is fraudulent, whatever. Someone will decide after the evidence. We will give our name of the witness, they will give their name of the witness. This DCP crime will come to the dock. The Borolumuk police officer will come to the dock. I'll see how they will give the answer, how they have looked at. Because now 3 of my affair is pending in the Borolumuk police station, not been registered. So we have to go to the CGM, file application that tell the Borolumuk police station to register the affair. That is the fate. When I read that paragraph, I'll also internal document from the crime department is circulated to plaintiff. How come, Lordship? If a DO letter from the High Court judge to the law minister, we go to someone and they will annex to the title suit. What type of thing going on, Lordship? And court will look into all these documents. But the certified copy is not given. A letter from deputy commissioner to someone, and it is very clear that the copy is given to so and so. How come that document is given by the plaintiff as a plaintiff document? I'll go one by one. So, and this Lordship, I have given today, Lordship, because 5-4 I have got the certified copy, Lordship. That is there. 5-2, Lordship. Only 5-2 I got the certified copy, Lordship. And today the matter is late. So only, Lordship can take the certified copy and return back that. Or Lordship has marked that, na?
Yes,
It is the Lordship can check, Lordship. It is the certified copy. This is the photocopy of certified copy. If Lordship want to keep the certified copy, I don't mind. Yes.
I have already marked here.
Yes, yes. No, Lordship can
Later
take
on,
the
you,
certified
keep
copy
the
also. That
certified
is what
copy
I'm
here.
saying. Lordship can take the certified copy.
Yes.
So that Lordship. Now, Lordship, may please come to paragraph 9 at page 80. Now they said that they filed application on such and such date before the circle officer. Then they waited. Then the original deed of so and so that is fraudulent and all that. That is at paragraph 9, Lordship. Then paragraph 10, that it is all decided and behind their back. They do not know anything, Lordship, about the But all this revenue authorities order was not challenged before the revenue board. Nowhere. Because the statute is there. Circle officers, you can go to the deputy commissioner. Deputy commissioner always go to the revenue board. No, nothing. Now, the facts is said like that. Then no, I'll go to that. I'll read the plain first.
Just go by the relevant para then. It's about.
Yes. Para 30 to 31, Lordship. Para 30 and 31. Page 91, Lordship.
Yes.
Why I want to read this? Because when he referred to my prayer, he has not read this. My learned friend has referred to prayer. Page 91, Lordship.
Yes.
Para 30. The defendant number 1 and 2 are person of desperate character and unlawfully occupying the schedule A land. Lordship will get it. Now, who has occupied? The defendant number 1 and 2. When, Lordship? The date is August 2023 when this suit was filed. তারিখ কিমান সুট মই দিনাখন উলিয়াই থৈছিলোঁ মই কোৰ্টৰ হেৰিখন উলিয়াই থৈছিলোঁ বিজনেছখন Schedule A land soon after the demise of late Bandana Medhi. Moreover, during the pendency of the mutation case number so-and-so, the defendant number 1 deliberately submitted a so-and-so with regard to residence of so-and-so in Santipur so-and-so Guwahati and did not in respect of the suit land. The defendant number 2. Now these allegations, Lordship, in the first part is against the defendant number 1. Not against me. He is not a party here. He's not a made party. The whole day argued against the Podip Das has done this, Podip Das has done that. He's not a party in the first place. The seat on the basis of the purported sale deed number so and so. As sir, the plaintiff pray, Lordship will take note. As such, the plaintiff pray for a decree of eviction of defendant number 2, her man, as an assignee from the Schedule A property to the plaintiff. So this is their plain, their paragraph. Then in August 2023, they won the recovery of possession from the defendant number 2. It's an admitted position. On oath. Because they've read my counterclaim and all that today, where I have filed, I have withdrawn, all that. That is also on oath. On what I have said something, on what they have said something. If Lordship, I am privileged, then Lordship will see my oath, Lordship, not see their oath, Lordship. I am not Lordship, that's the whole problem. Then para 31. Then the defendant number 2 is currently, clear statement, Lordship, clear statement, no hanky-panky. The defendant number 2 is currently in unlawful possession of the Schedule A land and is planning to sell the suit property. Therefore, in the event the defendant number 2 succeeded in alienating the entire suit property and third party, the same would not only result into multiplicity of proceeding, but the plaintiff would also suffer irreparable loss and injury, causing serious prejudice to the right and interest of the plaintiff over the suit property. The plaintiff therefore pray for a decree. Now what? Now what? Pausing. Of permanent injunction restraining defendant number 2, her man as an assigned from alienating or selling any part of portion, Lordship. Oh, now you can jump. Lordship, many decisions from Supreme Court said nothing beyond pleading. And you cannot sense the thing, no relief beyond pleading, all that. Now this is the pleading, Lordship.
No, but one question is there.
Yes.
In the earlier portion of 31, they are saying that they are in unlawful position. But the second part, if you go by the second part, they are saying that they are trying to alienate, sale or some portion of the land from this work. So in that regard, most probably permanent injunction is seeking.
Yes.
Restraining this
Yes. Very good. That is what I am arguing, Lordship. Lordship is very correct. Not to alienate, not to sense the nature and character and all that. Possession, you are in possession, so don't alienate. That is the permanent injunction. The height of permanent injunction, not to alienate. That's the, then, Lordship, yes. Only Lordship, now, if Lordship with that, Lordship will go to page 95. I'll stop there, Lordship, because he has come. Page 95. Top. Roman 7. Page 95, top, Roman 7.
Yes.
Decree of eviction of the defendant. Number 2, her man as an from the Schedule A property. From where? From where? Schedule A property. Then 8. Lordship is very correct. Then 8. A decree of permanent injunction restraining the defendant number there so and so selling any portion of Schedule A property. To the play from changing the nature and character of the Schedule A by raising any construction thereon. That must. First of all, Lordship, this is a permanent injunction. 34 proviso, Lordship, at the cost of repetition, I do not want to read. How, Lordship, no declaration, nothing, that you are the owner, you are the title holder, you have some interest, some here. In the probate case, I have already read, Lordship. The court said you have no interest, nothing, no title, Nothing, I will not give you anything. And where is the prayer for possession, Lordship? Where is the prayer for possession?
So
There's,
now
Lordship,
they are
Lordship,
claiming
Lordship,
the right
Lordship,
title
Lordship,
over-
if I say, evict him, and I will not say, give the possession to me, what is the position? Court will evict him. How the court will give the possession to someone? What is that declaration? That evict him and at the same time give possession to me. Give a declaration that I have a right to possess the land. Because of this, that I am the owner, I am the title holder, that my name is there somewhere, in the Zamabandi, in the somewhere, where the probate court said you have nothing. No, nothing.
No, here they are not seeking for any right declaration of right title over the property.
Nothing.
It's
That
not-
that is why I am saying those 34 and proviso lordship. How the suit is maintainable, lordship? Suit itself not maintainable, lordship. 34 proviso. They are third party lordship to that sale deed. Even to the property also. That is why the probate court, not only probate court, the other two court also has said, I will read that slowly. Other two court has also refused and rejected, saying the same thing, that what title you have, what right you have to file this application. And no appeal, all those has attained finality. No injunction. Except 11 and 13, any date lawsuit. Sir. Any date.
Okay. Yeah.
তুই 10 তারিখ পয়সা বললা তো
Okay, that's not good. Your convenient date is there any?
He said 10th lawsuit. I have no problem.
10th.
Or 9th even lawsuit.
No, that is not the issue. My
Oh,
date
yes.
may be.
Oh, yes, I know.
So 10th I can give you, but most of the matters may have to be deferred, I think, because this bench will be is changing now. Though it is a part third, that's why I have to hear the matter. Otherwise, bench will be changed. So কি করবো ওটাকে দিয়ে দিও নাহলে কি হয় দেখা যাবে বাকি ম্যাটার একজন করে দিব আর 10th, if 10th is convenient for you, we keep it at 10 or at 2 p.m.
At 2 p.m.
Lawsuit.
At 2 p.m.
Yes.
There will be many matters, probably of listing many matters, but somehow we'll try to find.
I'm grateful. Lord.
Lordship, interim order passed. There is an interim order, status order.
Interim to
The order dated so and so will continue, lawsuit. There is no interim order.
Status order is
The order dated so and so will
the
continue.
main suit.
Order dated 26/11, 2020.
602.
26, no? Or
No,
26.
sorry, 26.
26.
You take an order. 80. Get an order as the interim order dated 20/01/2026. We got it. It not mine. Okay. 2 p.m.